All right, good evening, everyone, and welcome to the June 15th, 2026 regular meeting of the Township of Montclair Planning Board. In accordance with the New Jersey Open Public Meetings Act, the Official Electronic Publication Act, and the amendments to the notice provisions of the Municipal Land Use Law, adequate notice of this meeting has been provided by posting a copy of the notice on the first floor of the municipal building, also on the Township of Montclair's official internet website, and on the statewide legal notices listings of the New Jersey Department of State. This meeting is being broadcast live on Channel 34 and is streaming live and will be available on demand on YouTube. This meeting is a quasi-judicial proceeding, meaning that the board has powers and procedures resembling a court of law, and we are obligated to objectively determine facts and draw conclusions from them in order to provide the basis of an official action. Any questions or comments must be limited to the issues of what the board may legally consider in reaching a decision, and the decorum appropriate to a judicial hearing must be maintained at all times. Fire exits are to my right, which is your left, and also the back of the room. And as to the order of the evening, each application hearing begins with the applicant or their attorney giving an overview of the application and the variances that are required, if any. We then hear from any expert witnesses the applicant may have to help explain the application and why variances are required. The board members may ask questions of the applicant, the attorney, and their expert witnesses. And if you're a member of the interested public but not a witness in the case, you'll have 2 opportunities to speak. At the end of each witness's testimony, you'll be given the opportunity to ask the witness about his or her testimony only. And that's not the time to tell the board what you think of the application. That actually will come later. And so to ask questions, you have to come up here to the front of the room, to the lectern, give us your name and address, and then ask your questions related to the witness's testimony only. After the applicant's witnesses and any objector or objector witnesses have been heard, members of the audience will then have their second opportunity to step forward. And at that time, you may express your opinions, positive or negative, about the application. Comments are generally limited to 3 minutes per person. And at the completion of the applicant's case, objector case, and public comment, the public hearing is then closed, and the board members discuss the case and vote. And at that time, you'll be able to listen to our discussion, but you will not be able to participate. Next up is roll call.
Mayor Baskerville. Mr. Borshoff is excused. Mr. Campbell.
Present.
Counselor D'Amato.
Here.
Ms. Gaines.
Here.
Vice Chair Graham.
Here.
Mr. Ian Wally.
Here.
Ms. Willis is excused. Mr. Orbea. Ms. Wallace, she said she'd be late tonight. And Chair Brodock.
I'm here. Next up, we have the swearing in of our board professionals.
Do you solemnly swear or affirm that the testimony you may give tonight will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Okay, before we get to the next agenda item, I understand that application 2959 Grafton Inns is not going to be heard tonight, Ms. Talley? They
That's
requested to
correct.
be moved to a different meeting?
They've asked that it be carried to the July 20th meeting.
Okay, so we'll carry that to the July 20th meeting with no further notice required? Okay. So if anybody's here for 116, 118 Walnut Street, just to be very clear, that will not be heard tonight. It'll be heard on, say it again,
July 20th.
July 20th, thank you. Okay, next up, we have the minutes from May 18th.
I do not receive any comments on the May 18th minutes. Are there any-
I would move approval.
All in favor?
Aye.
Opposed? Abstentions?
Abstain.
Okay.
Next, we have the minutes from June 1st.
And are there any changes to the June 1st minutes?
Is there a motion to approve?
I'll make a motion to approve the June 1st minutes.
Is there a second?
Second.
All in favor?
Aye.
Opposed? Abstain.
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 Okay,
Oh,
there
you
we
weren't
go.
here.
Yeah, I wasn't here, so I can't
Yeah.
vote on the minutes. Because I
So
can't.
what happens then if we don't have a quorum?
Do we have enough
to-
people?
You
Yeah.
have 2 people that.
Yeah,
2 people? Okay.
I mean, we
Two
have a
minutes.
quorum to hold the meeting, right? So we have enough, and just members abstain because they had to, and It's okay. Motion carried.
And if worse comes to worse, I'll vote.
Hey, you were there, right?
I was there.
All right. Next up, we have under old business application 2940 260 Park Street.
Good evening, Mr. Chairman, members of the board. Alan Tremulak, appearing on behalf of the applicant, 260 Park Street LLC. This is an application requesting that the planning board reconsider the decision that was previously made denying this application for site plan approval to construct a new 3-story mixed-use building on the property located at 260 Park Street. As you know, I've submitted a letter memorandum in support of this application. I'm not going to repeat everything that's in that letter because I know the board has reviewed it, but I would like to emphasize a few important points and also supplement it with some recent a recent decision that's very pertinent to this application. So, according to the 2022 zoning map, the official zoning map adopted by the town, posted on the town website, this property is zoned NC Neighborhood Commercial. The 2022 zoning map was in place when my client spent a lot of money to buy this property, relying upon the zoning designation that he looked at in the zoning map. It was the map that was in place when we filed this application last year. It was the map that was in place when this application was reviewed and processed by the planning department. And a determination was made that the property was in the NC zone and that the use that we were proposing was permitted under the zoning ordinance. And it's the map that's in place today. You know, the importance of the zoning map can't be overstated. I made this point, I think I may have mentioned it in my letter to this board, but I made it before the zoning board a couple of weeks ago. The starting point for anyone who practices in this area when an issue's raised, you know, if I get a call from a client or a prospective client asking me, can I do something, you know, with my property? Here's what I'd like to do. Well, okay, what's your address? The first place that I would look, and I would submit that any of my colleagues practicing in this area would look, is, well, what's the zoning? All right, first thing you do is check the zoning. All right, the zoning map says, in this case, NC zone. Go to the zoning ordinance, you can see what's permitted. That's the starting point for anyone who practices in this area, not only attorneys, but other professionals, engineers, architects, professional planners, lenders, investors, prospective buyers. It's the thought that, you know, you can't rely upon what the zoning map says is a scary proposition. So I departed a little bit from really where I was going here. But as I stated in my April 14th letter, the municipal land use law specifically requires that applications for development must be decided based upon zoning regulations in place at the time the application was filed. The zoning map is clearly a zoning regulation. The board is obligated to apply the zoning map, the zoning regulations in place when an application is filed. And again, this property was and still is located in the NC zoning district. You know, we filed this application, you know, asking the board to please reconsider and correct the prior decision which denied this application at the March 9th meeting. We believe the board's decision was, you know, an egregious and blatant decision disregarding the zoning map. and clearly legally incorrect. I pointed out in my letter, when I listened to the tape from the board's March 9th meeting, that, when this issue was first raised, at the fourth hearing on this application, after we had presented lots of testimony and made lots of plan revisions, ultimately resulting in a fully conforming variance-free application. But when the issue was first raised, your attorney instructed the board that the applicant was entitled to rely on the NC zoning and that the 2022 zoning map was controlling. Those are his words. And that was clearly the correct legal advice, which unfortunately a majority of the members who voted on this application chose to disregard. Also, Mr. Neese pointed out in discussing this issue about the zoning designation for this property, he told the board correctly, again, that the zoning board has legal authority under the municipal land use law to render official interpretations of any zoning regulation, including the zoning map, and that any interested party had the right to make an application to the zoning board. So we took that advice, and around the same time that we filed this application for reconsideration, I also filed an application of the zoning board for an official interpretation of the zoning map. That application was decided by the planning board 2 weeks ago on June 3rd, and the board rendered an interpretation that 260 Park Street is located in the NC zone district. That
was the zoning board, you said, right?
zoning
Board. Okay.
Right. The municipal land use law states, as Mr. Neese already, previously pointed out, that the zoning board has the right to make official interpretations. It's also important to note that there's a reported court case. The citation is Colts Neck Civic Association versus Colts Neck Zoning Board of Adjustment. As I said, a reported case. The citation is 315 NJ Super 240, Law Division 1998, where the court held in that case that when the zoning board has interpreted a zoning regulation, quote, the board's decision is final and binding as to all interested parties, including enforcement officials. In the Cox Handbook that I've previously cited, which is kind of the Bible for us land use practitioners in New Jersey, Cox states that that decision's not only binding on interested parties, enforcement officials, but also the planning board. So, so now you have, in addition to Janice Talley's memorandum that was provided to this board before the March 9th meeting, in which she rendered her conclusion that the zoning for this property has been NC neighborhood commercial for at least 50 years based upon her review of, I think, 5 or 6 zoning maps. You now also have an official interpretation of the zoning board confirming that the property is in the NC zone. So, as I indicated, so I'm asking the board to reconsider its decision, hopefully correct what is an egregious and blatantly incorrect legal decision, and to fix it. And, to fix it by, I don't think there's any need to reopen the hearing. We concluded the hearing after 4 nights of testimony and after eliminating all variances so that when this was presented to the board for a decision in March, it was presented as a fully conforming site plan application without any variances. And under the law, as I understand it, and as I mentioned in my letter, planning boards essentially have no right to do anything other than approve an application, perhaps subject to conditions, but that a conforming variance-free site plan application is entitled to be approved by the planning board. And, I would ask the board, based upon the arguments that we've made, to reconsider and correct the prior decision and to grant site plan approval subject to the conditions that were discussed at the March 9th meeting. And I have a list of those which I can recite now or at some future point. I'm sure Mr. Neese also probably has a list of conditions that were discussed. There weren't that many. But I would urge the board, to correct this decision, make the right decision, and really correct what's clearly a miscarriage of justice as far as my client, the applicant, is concerned. So thank you very much. I appreciate you considering this application.
So how would we go about changing our decision if we're not reopening the hearing? I don't know, Mr. Neese, do you have thoughts on that as well?
If we're not
Well,
reopening?
Mr. Trembulak just said he doesn't think we need to reopen the hearing, and I guess I'm not sure, how do we take a new vote if that's what the board is so inclined to do without reopening the hearing? Like, I don't.
Well, I mean, we can reopen it. I'm not sure for what purpose. We're not going to do everything all over again, present our case again.
I would agree, but wouldn't we reopen it in order to have a discussion about what you just?
Okay, you're right.
Like, I think procedurally we'd have to.
Yeah.
Am I?
I agree
off
with
on
that.
that?
Yes,
Yeah.
we have to open the hearing because it's
Yeah,
been
and I-
concluded in that regard.
Yeah, right.
So we need to open the hearing for a reconsideration, if the board is willing to grant reconsideration of its prior decision.
I neglected to point out, Mr. Chairman, I did renotice the application, republished notice, served notice on all the property owners, advising them that we were making this application tonight.
Okay.
So, I'm sure you have to reopen it if for no other reason than to reconsider and,
Kind of what I thought
Yeah.
would be the case. So I would move to reopen the hearing to have the discussion to see if this is something that we as a board would like to do, or at least to have the discussion, I should say.
Second.
All those in favor? Oh, wait, before we vote, I should probably say, so Mr. Neese, some people may or may not have been here for this application. I don't recall who was here.
I can tell you who's eligible to vote.
I was going to say, there's probably certain people that aren't eligible to vote on
Uh,
this motion.
Well, I have members who have either attended all 4 hearings or read, or certified that they listened to the video, watched
Okay.
the video. So eligible to vote are Mr. Campbell, Counselor D'Amato, Ms. Gaines, Vice Chair Graham, Mr. Ian Wally, and Chair Brodock.
Okay, so everyone who's present here at the moment is eligible to vote.
Yeah.
Okay. So we have a motion, we have a second.
All in favor?
Aye.
Opposed? Abstentions? Okay.
Okay, so you've made some recommendations, Mr. Trembulak. You were before the Board of Adjustment, and they heard this matter and concluded that this property is in the NC zone.
yes, and I should say that there was, I get what I would call opposition at that meeting. One of the neighbors had an attorney who presented a lot of the historic maps that, Mr. Inawali had referred to. So the board heard all of that and, again, rendered an official interpretation that the property was in the NC zone and that it did not have authority to, disregard the zoning map or to make legal decisions. I don't want to, that's essentially, all that matters is that they rendered an interpretation that the, 260 Park Street is in the NC zone. So,
Do we have a copy of the resolution from that meeting?
Is your microphone on? 'Cause I think that's a.
Do we have a copy of the resolution from the zoning meeting?
I have a copy of the draft resolution. It hasn't been, the decision was made, it's going to be adopted Wednesday night at the board's next meeting.
And I can confirm that I listened to the entirety of that application. I wasn't there, but I watched it on YouTube, And I will confirm that what Mr. Trembulack has said about the action taken by that board is correct.
May I discuss that? What I heard, I also listened to it. I heard that, this is why I think we need the resolution. What I heard was that the property appears on the 22 map. I didn't hear that they made an absolute conclusion that it's actually zoned correctly, given the mistakes that occurred before.
That
So I
wasn't
think
there.
it's very important to hear, I mean, for me anyway, it would be great to see the actual resolution so we can see in black and white exactly what they voted on.
I don't recall that being their charge.
Oh, okay, I could be wrong.
What
I could be wrong.
recall was that the board, the zoning board, determined that this property was in the NC zone.
Okay.
That was as far as they go. They didn't reach a question of whether it was correctly there or otherwise. They simply confirmed that this property was in the NC zone.
Because it was on the 22 map.
Primarily because
Yeah,
it was on the
right.
2022 map.
Right.
No, that was, I'm sorry, that was solely, it was, Attorney Sullivan said, the only thing we are doing here is verifying whether or not the property is on the 22 map. I believe that that's what he said.
Okay.
That's their only thing. So it was shocking to me, because I just thought that the process, and I don't really have a dog in this fight, really, but like, I thought that it was gonna go there for a historical review, or to see if the map was good, and it didn't, and it was something that we could have done there, and it was almost more of a waste of the applicant's time, because they just did what we had already done, which was see that it was on the 22 map. And I was led to believe by some light reading into the law that they would take a historical investigation, which is done in some cases, and they simply didn't do that at all.
But if it's on the 22 map, right, we have to accept that that's what developers are going to rely on. I mean, we can't expect a developer to do a historical review, and I think it's reasonable reliance, right? That's a legal term of art.
Yes,
So,
but
so-
nobody has claimed, and Attorney Tremulak is getting over his skis in suggesting to this body and to others that somehow we are suggesting that the applicant would not be harmed or would not have a legitimate cause of redress if they relied on a mistaken map. And from what I understand in other cases, what has happened is that the applicant then has damages. There are damages that are done. So nobody here has suggested that the applicant is not harmed if the map is wrong. Does that that should be clear, and you have not made that clear. You have made it seem as if we are suggesting that there would be no harm to your client. And we have not suggested that.
No, you certainly haven't suggested that, and certainly if this board's decision were to be upheld, then clearly the town would owe my client a lot of money that he spent in reliance upon an incorrect zoning map. But again, that whole concept that you can't rely upon a zoning map. Nobody can pick up a zoning map and make decisions and advise clients as to what they can or can't do. Is frightening.
Yeah, well,
that
it's
could
frightening
possibly
too
be
that the map,
case.
of course, yeah, it's a terrible thing if the map is wrong, but the map still may be wrong.
But in order to,
But the-
And
And
you're
in order
writing,
to
people are
address
writing it
that-
off, people are
but-
writing it off. And what this case is like, hear me out. This has lived in my head rent-free for a long time, and I've been thinking about it, is that this whole case is like one of those awful cases, of which there are many that have been proven, of babies switched at the hospital. And it's the same kind of a drama. What happens is, people come in, I don't think that this is my baby, and the hospital goes, it's definitely your baby. It's 100%. No one has ever switched a baby. That's the first thing they will say. And then they'll probably say, you're probably crazy for even thinking this. And then they will say, if you even say that, you're going to make everybody not have any peace of mind about their own baby. So just be quiet. And, at the end of the day, now there is a way to test if it's your baby or not. And the problem in this case is that there was no way to tell whether the baby was switched. And it's very frustrating. I'm not going to get too hot, but I believe that when we went through that motion, and there were mistakes that were made, I believe, on my part, which was that we took your client's time 4 meetings, as you said. It's a long time. And that's why at the end, it was a little rushed. But what should have happened was that there should have been a hasty, okay, let's look at the map. Let's look at the historical maps and see. And if it was wrong, it would be on the township. But to say that it's never happened, it couldn't possibly happen, and all this kind of stuff just doesn't, it's not commonsensical.
I'm not saying that there couldn't have been a mistake somewhere. There may have been, but there's been no determination that there was a mistake.
No one was allowed to
And-
make the determination.
Well, that's correct, because this board
Yeah.
does not have the authority to make that
So
determination.
who has the authority?
A court. And this was discussed at the zoning board hearing, that the remedy to the objecting neighbors is to either go to the town to have the map changed or revised, or go to court and let the court unravel this and make a determination after looking at all of the evidence and deciding what an appropriate form of relief would be. This board does not have that authority. This board it does not have the authority to disregard zoning ordinances. In fact, you're obligated to apply the zoning ordinances as part of your legal duty.
There's one other
You can't just
aspect
say-
to this.
Somebody raises an issue, at the last minute and gives you several zoning maps and then expects you to, just then disregard the latest zoning
Well, I
map
have
that's
to- I
adopted
have
by
to-
the town.
I have to respond to that. You're
Well,
probably speaking about, okay.
Let me just, I know, and I understand why you want to respond to that. I just want to, Mr. Neese was trying to say something.
Yes. Where the switched baby analogy falls down is that this zoning map was the subject of an ordinance adopted by the governing body. That's where that falls down. If there was a mistake, it's up to as Mr. Tremblak has said, it's up to the governing body to do the analysis or to require that the analysis be done, or it's up to a court. But I agree that it is not up to this board to do that level of analysis. That's not what this board is
Well,
about.
okay, it's obviously a faulty system because the governing body routinely enumerates addresses down, and if we're doing things like a parking zone, it'll be to the feet. It's 140 feet from this intersection, right? So the idea that it's just a visual representation and that apparently the original zoning ordinance, it's not enumerated by block and lot, is that correct?
It is not.
Well, that's bad. That's the source of the error.
There's,
All right, so two,
there's no error or ambiguity or lack of clarity in the 2022 zoning map. Okay.
so let me jump in with a couple things. One, Ms. Wallace is here. Welcome. Is Ms. Wallace eligible to vote on this
she's
matter?
not.
She's not. So we're on 260 Park, just so you know. But so you can participate, but you can't vote on this. No problem. I was the first one, and then I did want to give Mr. Ian Wally an opportunity. He wanted to respond to that.
There's
comment by Mr.
mischaracterizations
Tremblak.
of what happened. What I did at that March 9th meeting was take what was given to us by the planning department. I looked at the maps and I very simply counted the parcels, 12 of them, to a line. And I was absolutely sure that the maps that were in that packet, they weren't my maps, they were maps that were presented at the meeting. The 12th parcel is in R2 up to 2006. The next map that was authorized is in 2017. In fact, if you click on the website, the Montclair website, click on the PDF version of the current zoning map, the 17 version comes up. 17 is changed to NC. So I'm thinking, well, it goes to the zoning board. The only thing that needs to be done is that someone needs to provide a resolution changing the zone in this property somewhere between 2006, when it was in R2 on the maps that we saw, through 17. The 22 one is sort of moot in a way because that's an online map. I haven't found an actual PDF of the 22 map. And I think that we have to be careful with using ArcGIS to represent zoning maps because they're kind of fungible. They could, I haven't found a PDF version. I don't think it's on the website. I see the zoning viewer, which I think is supposed to be the 22 version. The PDF on the township's E360 website is the 17 one. But even on 17, this property is in NC. I'm sorry, yeah, it is in NC. So the error must have occurred sometime in those 11 years. So when you
Well,
say
I
that
don't-
we don't have the authority to act, we certainly have the ability to ask questions and wonder what happened. And I think that there are a lot of residents who also have an interest in what happens on this property. You can say, well, yeah, you can't set a precedent to say that the zoning map has to apply because purchasers of property may be harmed. But by the same token, I don't think that we want to set a precedent where those that live in neighborhoods are harmed by potentially incorrect maps that are filed. It works both ways.
There's nothing incorrect about the 2022 zoning map or the 2016 map. And to say that there had to be a mistake somewhere is wrong.
Well, I disagree.
And the
but
zoning
that's
board,
okay. don't
but I
need
think
to-
the zoning board made a determination, and we're not the place for this investigation, right?
That's
Again,
correct.
the place for this investigation is the courts. And I think with the application being presented without any variances, the fact that there was a map that they relied on that clearly demonstrates that it was in the NC2 zone as of 2022, I don't see any legal basis for not granting relief to the applicant. I just don't see it, guys. And we can speculate here, and we could say that the baby was switched, but I haven't heard proof here. And I think the reason why we're not the right, we've heard people have investigated this, right? The board has investigated it, there have been members of the public who investigated it. We don't have any definitive time to say this is what happened and this is where it was switched, which further indicates that we're not the right body to make that determination. If it's going to be determined, it's got to be done through the courts. I haven't heard any definitive evidence that it was switched, let alone when it was switched, and by whom, and by what
But
body.
the burden to the challenger in the courts is so high.
But that's not for
The point is
us,
that the
that's
zo-
not for us to litigate. That's not for us to litigate. It's not. It's just not our purview.
Maybe easier question, what new information is coming on Wednesday? I heard it suggested that there's some new
I think
information.
the zoning board of
The
adjustment.
The resolution indicating that this property is in the NC2 zone. Now, again, my personal feelings about this application, right, have nothing to do with which way I vote. I'm voting based on the legal requirements, and I see them having satisfied each of those legal requirements, and I have not heard any indication or any real proof that the baby was switched, as the counselor had indicated, had suggested.
So why not wait till after the resolution? Maybe I'm missing that.
Because we know what they said, we know what they voted on, right? Mr. Neese confirmed Mr. Trembulak's interpretation.
It wasn't an interpretation. It was a conclusion.
Conclusion, thank you.
But that conclusion becomes real with a vote.
They voted, is
They
my
voted.
understanding.
This is
They
just a
got it.
memorialization.
Memorializing,
Just like us.
When
Yeah.
we vote
Yeah.
on an application, that's the decision, and then we later memorialize it with a resolution.
Yeah.
But the actual action is us
Happened.
taking a vote on an application, I think similar to the zoning board. When they take a vote on an application, that's the decision.
Got it.
I'm sympathetic to the objectors. I'm sympathetic to the idea that there may have been an error in the map at some point. But we are not the body to make that determination, and we do not have the evidence to definitively show that there was a change in the map, and when and why.
I also, if I can just respond to one thing Mr. Inawali said regarding the 2022 map, and this was part of the evidence presented to the zoning board, and it's public record. The zoning 2022 map was adopted by ordinance O-22-16 on July 26, 2022. It's codified in the zoning ordinance, and that the zoning ordinance provides, quote, "The boundaries of each of these zones as created in this by this chapter are shown on the zoning map, Township of Montclair, as prepared by the Department of Planning and Community Development and amended through June 2020 22, which is hereby adopted and made a part of this chapter.
So let's assume that's when this changed. Let's assume that's the
No,
date.
no,
No,
because
I'm
I-
just saying, just
No,
for
but-
argument's
but-
sake.
no, but
But
no,
Tony, I
but-
just want to finish this one point.
Well,
Let's
okay,
assume
but
for argument's sake that was the
I
date.
can't assume something that's wrong.
No, but let me just,
there is a-
let me just
let him
finish
make
this
his
point.
point.
Let's assume that was the date that this all changed and that the property was placed in the zone. There is an ordinance memorializing it. There
there's
is
not.
reasonable reliance for the applicant to determine that that's in the NC zone. I do not see any argument that we can deny this request for relief. I just don't see the legal basis.
Mr. Ianwali.
Okay, so there is a PDF. First, I've never, like I said, I've never seen the PDF version or a fixed paper copy of the 22 map.
Here it is.
Okay.
Do you want to
Okay.
say it?
Where is
You know
that?
what it's gonna
Mr.
show.
Trembulak,
Well,
where is
no,
that?
it
Well,
shows it's in the NC zone. I said even one earlier than that, 117 also shows
Yeah.
it in the NC zone. Absolutely. It doesn't mean that that's correct. The 22 ordinance that memorialized the zoning, specifically, the purpose of that ordinance was to change the zoning in the C1 zone and up on Glenridge Avenue. And that was the purpose of that ordinance. The primary purpose wasn't to ratify the zoning. It basically said that we're changing the zoning, increasing step backs on the C1 properties, and we're changing some of, I think it might have been Portland Place properties from C1 to C3 to help reduce some of the massing there. That was the purpose of that ordinance. And they said, by the way, those changes that are referenced in particular are documented in the 22 zone map. So the purpose of that wasn't to say the whole town map has been evaluated and it's official. The purpose of that ordinance was to change the specific zoning changes that were adopted by the council in 22. And by the way, this property was on the 17 map, also in NC. But that doesn't necessarily alleviate the fact that it's wrongly on the 17 map, as shown. I mean, we went through the process. We were shown a memo which said that it had been in the NC zone since the 70s. I used the maps that were given to us and said no. No one has said that I was wrong. They said that.
I disagree. Your town planner said you were wrong. She provided you with a memo reviewing every zoning maps from 1974.
Well, that's where I found the errors.
Okay,
Folks,
well, you disagree
Okay, whatever.
with your planner. You ignore the advice given by your board attorney, who says that the 22 map is controlling, and you're just going to decide there was a mistake somewhere and deny this application? That is so blatantly incorrect, and it's so
the map-
fundamentally wrong.
The map
and beyond
was
your
adopted.
authority to make that determination.
I
Mr. Tremblay,
evaluate
okay.
what's
The
in.
map was in
everybody's made their
fact
point.
adopted in 2022 via an ordinance. That map was adopted. Again, it's not for this board to go to look behind the ordinance, look behind what was going on, because you think that there's an error that may have been committed. This board has to enforce the regulations of this township as they are written. You don't have the ability, as we've said over and over again, to say, well, there could have been, might have been, probably was a mistake. The fact of the matter is that the ordinance adopted the 2022 map. This application came before this board on the basis of the 2022 map, and it is entitled to, the ordinance itself is entitled to a presumption of validity. And that's something that this board has to just rely on, just as the applicant relied on that as well.
Well, this body and other, parts of the township also had an obligation to help people understand what the law was. And I'm not pointing at you, but just that, what the channels were. And that's broke down. So you had people not really knowing what the process should be. And I do not know if the attorney that Ms. Pickett retained to make that thing showed up, clearly thinking that there was another way.
Counselor, that's a different question than the board is facing here tonight. Much different question.
It isn't, because I didn't know. I believed that when we ended that night, that there would be a determined, that it wouldn't just be another set of eyes going, is it on the 2022 map? I thought it was going to be something different. So
What did you think? I mean, what could there have been in your mind?
there could have been, I mean, did you think that that's all they were going to do? You're much more.
I've gotten in a lot of trouble so far for speaking. I think I'll be quiet for a while. All I'll say is that I evaluate everything that's been put in front of me, and I make judgments as to the truth of what I'm looking at, period. That's all I'm going to say.
And we appreciate that, Mr. Ianwali.
Yeah.
We may not all agree. And I think that's one good thing about this board. We don't always agree. We have different opinions, and we're supposed to. That's appropriate. So I appreciate that you do take the time to go through these things. Me personally, I think you might be right in terms of a mistake being made somewhere. But I also agree that the zoning ordinance is the 22 map. It's the online map, and that's what we have to go by. And as much as I would love to, really dig into some of these, past maps, and like I said, I happen to think just from simple counting, you're probably right. But in terms of what I think the board can do, I happen to agree with Mr. Neese that it's the 22 zoning map is what we have to rely on, whether we like it or not. And I struggle with that too. I struggle with relying on something that I'm not sure is totally correct, but I also recognize that that's what the governing body said is the zoning map. Right or wrong, that's what's in front of us, in my opinion. And
Does the
so
law make a distinction where the body recognizes that there is a likely error?
I would turn to
It's a
Mr.
question for-
Neese and ask if that's.
But it was voted on in 22, right?
But
The ordinance was
yeah.
voted on in 22. I think
I'm just
for
curious if there's-
the idea that, the governing body doesn't have the authority to vote on a map that developers can then rely on just doesn't make any sense to me. I don't see how legally we can have any kind of certainty, any kind of
I think those are two
reliability.
questions.
I don't see how developers can come to this town and function without a reliable map.
Dangerous.
Of course.
And the body made that it was incumbent upon somebody in 2022 to say, hey, guys, we've got to pull this property out of the NC zone, right? That's procedurally, that's when that should happen. Us looking back now, it's too late. It's too late.
The governing body can go back and take a
Okay.
look, but what this board, at least in my opinion, cannot do is take that out on this applicant, because this applicant relied
At the time
on
of-
the township map.
And it's a reasonable reliance too, right?
Sure.
I mean,
I don't
if
debate
I
that.
were a developer, I would look at the map and I'd say, okay, it's the NC zone. I would not think that I have to go back and look at the history and say, hey, wait, did the governing body make a mistake? I have to rely on the governing body, right?
Folks, stop, please,
I
please.
can't address you directly.
Please, we're not
Yeah.
taking questions at this point.
Where were we?
Ordinance,
Yes, thank you.
zoning ordinance by the governing body.
My curiosity, if anything, is what's our responsibility as it relates to potentially passing down an error or potential error? And I appreciate that our responsibility is not to litigate or relitigate. I understand we are managing the facts that are in front of us. I
Correct.
think there's reasonable suspicion here. And so my curiosity is there a case law precedent on how we might handle that? And if it is that we usually ignore what's sort of in front of us and react to what's been presented to us most recently, then I guess we'll have to decide based on that.
No, that gets us down the same rabbit hole that
Yeah.
we are currently in. The board doesn't, it makes no sense, as Mr. Graham says, it makes no sense for the board to look behind an ordinance or a map or something. Take a different situation. Suppose the governing body says that 2 + 2 = 5. And an application comes before this board, and the applicant says, board, 2 + 2 = 5.
Yeah.
You know that that's not right. I know that that's not right. But the governing body made that decision that 2 + 2 = 5. Therefore, this board, our jurisdiction is somewhat limited. We can't
okay.
countermand that.
And who do we flag in that scenario? Who do we flag that?
Well, I was going to say that we have somebody from the governing body who's heard this, and
Okay.
and I'm not saying,
This be
Mr.
Before my time.
Counselor D'Amato, yeah, I'm not saying
Yeah.
you were part of it or that this is something you needed to even take up, but that's where, you know, a
Got it.
change like that would occur through the governing body taking it up and saying, hey, we need to reevaluate zoning for this property, other properties, or, you know, entire districts.
Clear.
Well, again, I'm not suggesting that that a developer or anybody coming to town wouldn't have confidence, because the idea is that if the map is faulty, they're gonna have redress, right? They're gonna get paid out. So like, it's not a question, it's
That-
true.
Well,
It
that
happens
is
in other
true, but
places.
that's really not an appropriate,
But it's also not appropriate to say, well, there's a mistake and we're just not gonna worry about it.
But-
Like, they
but
both suck.
How can you say there was a mistake? You think there may have been a mistake.
Yeah.
Okay, there may have been a mistake.
Yeah.
Okay? We don't think there was, but there's some clear legal principles here, that the applicant is entitled to rely upon. Number one, all municipal ordinances are presumed to be valid until shown otherwise, okay? Okay? This board, and I represent several planning boards, and I had legal issues that have come up. I've seen ordinances that I know in my mind that are not valid under the current state of the law, but I've had to advise my boards, you don't have the authority to disregard or not apply a legally adopted ordinance, even though it may be legally incorrect under the current state of the law or whatever. But number one, ordinances are presumed valid until a court determines otherwise. This board doesn't have the authority to review historical zoning maps and say there was a mistake and we're disregarding the zoning map. That's number one. Number two, in addition to presumption of validity, the municipal land use ordinance provides that, quote, development regulations which are in effect on the date of submission of an application for development shall govern the review of that application. There's no question what regulations were in effect at the time this application was filed. This is the 2022 zoning map. And the 2022 zoning map was legally adopted by the town by ordinance in 2022. It was in effect the day that we filed this application. It was in effect throughout the application. It's in effect today. To simply suggest that this board can disregard that.
It can't.
It
The board
can't.
can't disregard
It can't.
that, frankly.
And we shouldn't have to go to incur additional expense and delay by going to a court and having a court make that determination, which undoubtedly it would do, I believe. I believe your attorney feels that way. I think this board should fix this. This is just wrong. You can't just well, there may have been a mistake, so we're just gonna just disregard the whole zoning map.
Can't do
And
that.
You can't.
Unfortunately, that is this board's lot in life, that you are required to consider the zoning ordinances and the other ordinances of the town and enforce them as you understand them. Looking behind ordinances, looking behind the map, trying to figure out at this point in this application whether a mistake was made is not relevant for your consideration. This application comes to you as a variance-free application. No variance is required. So you've seen these applications before. You've seen applications with no variances. You've seen applications with variances, and I've seen this board use a little bit of muscle, shall we say, in order to get things for the township when variances are an issue, but that's not the case here. There are no variances being requested. So while the board is not obligated to decide in favor of this application, I think, to use the term presumption, would probably be appropriate. There is a presumption that this application ought to be granted.
Because of the lack of
Because there are
variances?
no variances. The applicant conforms to the zoning ordinance. There's no variance required. It's fully conforming. There's nothing really for the board to do, except approve it.
Okay. Other,
What conditions, if any, are within our authority? I think that's a question for you.
I'm sorry.
What
Tamar, I
conditions?
can't go- Is your mic
Sorry.
on?
Yeah, sorry about that.
Sorry.
Yeah, I'm curious, what conditions, if any, are within the board's authority at this point?
What
Yeah, that we would-
conditions?
Yeah, I'm,
As a result of the application, I don't know, I had a couple of them, but I'm not sure that I have all of them. I didn't, several
If I
were
remember
taken
right,
care of.
there was a motion and a second, and then the motion didn't carry on this application. Is that correct?
A motion to,
Originally, was there a motion to approve this and it didn't carry by a majority, therefore it was denied? Is my
That's
recollection correct?
I think that is correct.
I have the minutes, that's
So there-
stated
there-
in the minutes.
So there would have been conditions with that motion to approve.
Yes.
And this is stretching back, what, 3 months? 3 months ago, so,
As I recall, based on my notes, the applicant agreed to all of the board engineer's conditions with certain modifications, that the applicant would put conduit in the ground for future EV. There would be no outdoor seating at the restaurant. The lighting at the property lines shall comply with the township's ordinance.
I think there was also a condition that there be a flashing light at the sidewalk or some other warning device for pedestrians.
Yes,
that would be
I-
subject to
right.
the- and
I had the flashing light as a question mark, and then I think later discussion was that there would be a building-mounted warning device.
On the
Not necessarily the
the-
flashing lights. I think there was some complaint from the neighborhood about it.
Yes.
With the one in the
westerly-
sidewalk,
yeah.
They
Right,
didn't
Yeah.
work, or would,
Or is it
It's hard to
too
maintain, something like
intrusive
that.
for the neighbors? Yeah,
Right.
to clarify, there's no
Um,
new conditions that we could enter into the conversation at this point. It's sort of, it sounds like take it or leave it, based on where we left off. Is that?
I mean, there's no new evidence other than the representations of what the zoning board decided.
I'm curious to hear from the public if that's,
We'll take public comment, but I want to get through all of our questions, comments first,
okay.
and then we'll get to public comment.
the applicant will work with the board engineer regarding a bollard light on the north side, bollard lights on the north side of the property. I don't know that this was a condition, but the applicant made a representation that it was not going to be a pizzeria on the first floor, it will be a bagel shop.
Did that change seating? Do you recall? Is that
Yes.
why they made that representation?
reduced the
Okay, so
seating.
that would have to be part of
Right.
be a condition, right? You couldn't change to a more intensive use. I mean, whether it's a bagel shop or something else, I would say that's probably not.
Well, then, I think it was you, Mr. Chairman, who said that, you know, if they come back, or if there is a more intense use that's put in there, they would have to come back before the board for consideration of the parking aspect of it.
So I'm consistent 3 months later.
You are
Okay, good.
consistent.
That makes me feel better about my memory or my approach.
As I
Last thing.
recall, Janice, the applicant was also very generous in terms of stormwater retention early in the design, but that's in the design.
That's in the plan.
That's in the plan, okay, thank you. And thanks for doing that.
Okay.
Any other questions or discussion from the board? I know, this is not an easy
This
one,
is-
right?
this is good
why,
conversation.
part of the reason why this has taken almost an hour to have this discussion is because this is not easy and this is not a normal thing that comes before us. So want to make sure folks have as much time as we can give to ask questions and, you know, have their opinions heard.
So just procedurally, before we move on to the public, if we hear from the public and are interested or curious to enter in new conditions, is that feasible, or is that is the line sort of drawn here?
I would ask what it's based on.
Sure.
I mean, we
No,
haven't
yeah.
heard,
Yeah.
new evidence, like they changed the facade, they
Yeah.
changed the use, so I
Yeah.
would question why now.
Sure.
Certainly, if it's something that you recall and said, oh, I think they testified about this, we wanted to make sure that was in there,
Yeah.
then I think yes,
Yeah.
but,
Unlikely.
Unlikely.
yeah, I think unlikely, because we really haven't heard new evidence other than a confirmation by the Zoning Board of Adjustment that this property is in the NC zone.
Fair. Okay.
Anything else from the board? Okay, we'll move to public comment. And I know a lot of folks there's no questions because there's no expert witnesses been here. We've had Mr. Trembulac. We're going to go to comments, right? So we'll do public comments, about 3 minutes per person. If somebody has a question, ask it. We'll see if we can answer it. I don't know if we'll be able to. You've heard a lot of the discussion about, we've asked a lot of questions. I'm sure you'd still have some questions. We may or may not be able to answer them, right? It's supposed to be for public comment on the application as a whole. But I understand this is a more challenging application at this point and more challenging request that the applicant has brought before us. So we'll be a little lenient, but I won't promise I can answer anything. So if you have comments, come up to the lectern.
Do we ask a question to you?
I'm saying you can try, and I'll see if I can answer it, because I don't know if I will, but I want to make sure that,
This is not
well,
my
we need,
comment, This is my question.
well, we need to make sure you're on the record, so if you can
No, I understand.
make sure the light's
I'm
on.
moving, I'm slow.
No, that's okay. I'm going to give you all, I just don't want you to start talking before we get you on record,
Is the light on?
right? Because everybody has good comments, right? And we want them to be on the record. And I think Ms. Talley is going to make sure your mic's on.
Yeah, it's on.
And then we're going to ask you
It's
for your
on.
name and address for the record.
Yes, Gerald Fears, 259 Park. My question to the
Can you
board.
repeat your name? I didn't get it.
Gerald Fears,
Okay.
259
All right.
Park Street. My question is, have you actually read the 2022 ordinance that has been discussed at this meeting with its map of the C3 zone, which is over by Bloomfield Avenue, Park Street, and Porter Place? It very clearly talks not about the entire zoning map of 2022, but talks about the particular changes that are going to happen in the C3
I think that's what
area,
Mr.
and then encloses the map of the C3 area.
That's
So
what
I
Mr.
just want,
Ianwali
my question
mentioned.
is, have you actually looked at this? If not, it should go into the record, and you should look at it. Thank you.
And the board did discuss that, yes.
Claire Ciliata, 279 Park Street. Mr. Tremulac, I have a question for you. Does the ordinance supersede a map in law? Does an ordinance, a zoning ordinance, supersede a map in law? Which one is lawful and which one is merely an addition to the law?
I don't think either supersedes the other.
Really?
You have a
Let him-
zoning
let him finish.
ordinance that creates zoning districts and
Well-
provides, can I finish?
Sure.
Okay. You have a zoning ordinance which creates zoning districts, residential, commercial, et cetera, and what's permitted in those districts and what the setback requirements are and the height requirements and all that. And then you have a map which lays out the boundaries for each of the zoning districts referred to in the zoning map. You have to have both.
Well, I know you have to have both, but my question is, which one holds the weight of law? Because
both
if
do.
you're going
They
on-
both
And he
do.
answered it.
Well, I don't think he answered it.
Well, he
because
answered it.
when
You may
I-
not agree, but he answered it.
I don't agree with you because I checked with Rutgers Law School and I was informed
But we
that
can't,
the
that
zoning
doesn't,
ord-
that, we can't take that into
Okay,
evidence,
so-
unfortunately, because
So
they're not
what-
here, right?
All right, so what I'm saying here is that this is here, and nowhere on this is our map? Nowhere. And yet you are talking as if this supersedes everything else. First of all, who changed the map? Ms. Talley, you're in charge of that. When was the map changed?
It's not
Because
Miss-
it wasn't
it's-
changed through this. It could not have been, because there's no evidence of our zone on this map or this hearing. So who changed the map?
That's the governing body who,
The governing
Decides the
body
map.
changed the map. So if the governing body makes an error, then you're telling me that I, as a citizen, have to pay for that error.
well, what we're saying is that this board does not have the ability to change that.
Well, here's the thing. Our citizens, all of us, have been coming here to every meeting. We have
Correct.
raised this issue many, many, many times at these meetings.
And it's not for this board to change. That's the
And we have
issue.
gone to the Board of Estimate, we have gone to the town council, we have gone to all these meetings, and this issue, everybody keeps talking about the map. The map is not the issue. The issue is there a specific ordinance that says that map is correct? Not, it doesn't go the other way, like with the baby. It's not, oh, the map is maybe an error, but it's the map, and so we have to go by the map because it's terrifying not to go by the mistake than to go by the law. This does not say anything about where I live, and that troubles me, because you keep getting caught up on this bloody map, and the map does not hold the legal status that an ordinance does.
The map, the zoning map is adopted by ordinance. When you adopt a zoning, or a zoning map, or a zoning change,
But
it's
you
a
have to say the change, Ms. Talley. Where does it address the change in my district? It doesn't on this zoning ordinance. I've got all of it in front of me. It doesn't address it. So I could go and make a whole bunch of changes on that map, and you're telling me that if I'm talking about C1 and I pass that ordinance, that everything else stays on the map and has to be right? Is that what you're saying?
If the governing body makes those changes, I'm sorry, I don't
No,
understand the
there's no-
exact.
If the governing body doesn't make, somebody makes an error.
It has to be, though, approved by the governing body, and those are the rules of the road that we have to live by and we have to abide by. So if the governing body would like to change those or vote on a change and pull this out of the NC zone, I think it's too late for that at this point. That's where the redress of grievances would come
The
from.
irony of this, to me, is that had someone filed to do not a mixed use, you would not have us standing here crying.
Are you saying if they got rid of the restaurant use, you wouldn't have,
Absolutely.
if it was just a multifamily building?
Yes, because.
You'd be fine.
Because the westerly, right,
Okay,
doesn't give us a lot of traffic. What gives us a lot of traffic is that bloody deli.
I think we hear the message.
So, there you go. Thank you.
I hope I can get all this out in my time.
Your name again? For the record.
Yeah, this is all for the record.
Yeah.
Donna Pickett, 255 Park Street.
Thank you.
I'm here to respectfully tell you why your decision on March 9th was correct, and it should be reaffirmed. So we know what Tony said about the historical maps. I'm going to just give you a timeline, and I'm going to tell you the truth of how we got here. And I know you're searching for facts, and I'm going to lay them out. So, as I said, we know what Tony did at the planning board meeting. I had 6 OPA requests. So an OPA request 25, 28, 24 from December. So I just want to say for Mr. Tremulak, I started this analysis in November. I alerted the town in December, so it wasn't the 4th meeting. And the town's reply on my ordinance request says, quote, "There are no records of rezoning for 260 Park Street. Attached is the zoning map from 2006, which is the basis for the new map prepared in 2016, which is also attached. All records have been released and your request has been fulfilled." We know-
Mr. Neese, do we need a copy of this?
My attorney read it to the zoning board, so it is on record.
I think.
I'm asking procedurally.
Yeah,
I
I
have it
think,
here.
my recollection is that Ms. Pickett's letter or her Oprah request was part of the record?
Part of the letter?
That
Okay.
that we reviewed?
submitted.
Okay, I just want to make sure there's,
Well,
if
in
it's
the
new
ta-
evidence.
It's in the town portal, and my attorney read it at the zoning board meeting, and I
Okay.
have a copy here.
And it was provided with the letter that she sent to
I-
the
I-
planning
Right.
board that triggered this whole.
I'm just checking,
No, I'm just
right?
saying.
Okay,
No,
I hear a little bit of
Yeah,
tension,
yeah.
and I know there's
It's
tension
nothing-
with this,
it's
but
nothing new.
Right.
I'm just
Yeah. So, but
making
these are the
sure.
own words from the town.
Thank you.
That there are no records of rezoning 260 Park Street. That's what the town told me. Okay, so I do believe the truth matters, and I'm going to give you this timeline of events and show you how my attorney debunked the planning board's members' March 3rd memo. So that March 3rd memo from Janice Talley has 6 maps. And Ms. Talley and Mr. Trimilek have said the 1974 map it goes back to being in C. That is not true. I have the maps here, if we want to look at them. So
Well,
historically,
we have
the
the
same
maps
maps.
and evidence
the
already.
Okay, but I'm just saying that they're saying that that property went back to the 70s to be in C. That is not true. That is not true. I have the maps here.
Ms. Pickett?
I can count them.
Can I respond to that?
Sure.
I just want to say, everything that I uploaded was prepared by the zoning officer. There's always interpretation. His interpretation, pulling those old maps, was that they were all in the NC zone.
Well,
They were,
I can-
and I've said before, when I took this job, the quality of the maps that I inherited required my staff to do a lot of interpretation. And that's the background, and that's why in 2016, we had a subcommittee, and we spent over a year working with the subcommittee and members of the planning board, the council, and the zoning board to do the new zoning maps. So there may be disagreement in how you interpret the map versus how the
Well, I
zoning.
can count, I can count.
Finish,
and
ma'am?
I can count.
Can you let the town planner
Sure,
finish her
sure,
comments?
sure.
So your
She's
ma-
an impartial
Sure.
person.
So that's what was presented to the board, that's what was uploaded to your request. Clearly, you disagree, but that's why a lot of what we do is interpretation, because it's not clear.
But it's very clear here, and I'm going to count for everyone. My attorney, Exhibit 01 at the zoning board meeting, 1974 map. I will count on this map in 1970. No, it's no interpretation. It's easy, like Tony did.
Well,
I'm
then that's,
counting from- let me
and Ms.
count,
Pickett,
let me
well,
count.
hang on.
You're not the-
Ms.
You are not the
Pickett,
zoning officer,
I know,
Hold
I'm
on,
not, but
hold
I.
and that's the job of the zoning officer.
But
I'm
I
not
can
sure what
read
this is.
black and
what
white.
the
I-
and
purpose-
I
I'm
can
trying to
count. I can
interject
count,
here.
and it's
I
in black and
understand.
white.
And I,
if
and
you count here,
Ms.
these
Pickett,
maps,
and Mr. Ian Wally did that and presented an
he
exhibit to the
counted a
board.
different map. I'm counting 1974.
Is the result
Exit-
the same?
But I don't know why no one's not believing me. I have my.
I'm not saying
I can count and I can read, and I'm
And-
counting from Gordonhurst down on the 1974 map. It is residential. And I
I-
am counting on the 1979 map, Exhibit 2 that my
And
attorney
you
read.
heard me say, I personally think Mr. Ian Wally's probably right, that there was an issue at some point. But you've also heard myself and several others on the board say, it's the online zoning map, it's the 22 map that governs how we interpret this applicant's application.
Okay, well,
And that's the
historically.
difference.
Historically, we have it here, my attorney debunked it, that the being NC, they are marked as residential, those maps. Now I'm going to talk about my analysis that I did start in November, and the truth is that there is no record of an ordinance. There's no language amending the chapter 347 of the Montclair Code that designated 260 Park Street as NC zone. There's no language in it. I have it right here. I can read it again. Jerry just brought it up here. He read it.
Mr. Ian Wally brought it up tonight as
You can talk about
well.
interpretation of the boundaries, but it does not point out specifically that lot and that address.
I understand.
And then, let me just get back to here. A lot of documents. So you don't have any publicly available meeting minutes, resolutions, or codified documentation from any governing body reflecting a public hearing, adoption, or effective date changing the zoning for 260 Park Street. That's a fact. There's no record required of public notifications within 200 feet. That's a fact. You don't have it. In summary, all of this documentation that I have asked for, it is not there. You don't have anything to back up that 2022 map. You don't have an ordinance. You don't have notifications to the neighbors. You don't have meeting minutes. You don't have any documentation to back it up. I don't know what you guys are looking at, but this is all the facts and truth. So I'm going to talk about Mr. Trimilek's April 14th email. He's telling you that your decision that you made is legally flawed because of NJSA 4055D 10.5, time of application. The truth is, the New Jersey Supreme Court time of application rule only protects a submission to include the application form and all accompanying documents required by ordinance. Nothing in that ordinance says anything about 260 Park Street. So my attorney debunked that on June 3rd. That's the truth. Mr. Trimilek states, Mr. Ionelli said he believed on March 9th that a mistake was made. I want to clear the record. He did not say that. He said, I think the town never intended for 260 Park Street to be in C. He counted the lots to prove it, and you can watch the video. Mr. Trimilek's April 14th memo talking about Janice's March 3rd, 2006 memo, he said, quote, review of the historic zoning maps shows that the subject property was included in the NC zone since at least 1974. I just showed you the map, 1974. It's clear, it's residential. I can count, I can see. Tony can count.
Okay.
We can all count. Some people can't. A couple people can't. And my attorney
Thank you, Donna.
debunked that.
I appreciate that, Donna.
Page 2, Mr. Trimilek is distorting the facts. He states, quote, the decision was based on a single board member's personal opinion that he was pretty sure. Tony didn't say that.
So you have an issue with Mr. Trimilek's letter?
I'm having
Okay.
an issue with it because it's not the truth. He's saying that the board made a decision on a single person. That's not true. The board had each person made their decision. It wasn't
Correct.
based on Tony.
You're right. And Ms.
And
Pickett,
Mr. Trimilek did
we
not
were
give the
we
full
were all
Mr.
we were all
Trimilek
present.
talked about the Cox and Koenig reference to New Jersey Zoning and Land Use Administration. He didn't give you the full context. Cox and Koenig clearly state ordinance text is the law. There's no text in 2022 ordinance
Okay.
that points out 260 Park Street.
We've
Mr.
heard.
Trimilek also points out
Ms.
Dunbar
Pickett,
Homes versus
Ms. Pickett,
zoning
you're pushing
of
3
adjustments.
minutes.
I'm sorry?
You were pushing your 3 minutes
I know,
by a
but
long shot. Well,
okay,
but Ms. Pickett,
he even puts 2002 in his letter,
Ms.
saying that he
Pickett,
put the
we-
application, filed
Ms.
the application
Ms.
on the
Pickett,
map for 2002. He
Ms.
made a
Pickett,
mistake.
Ms. Pickett,
All right,
please.
okay.
I understand your point,
Cut me
and
off. I'm almost done here. I'm almost done.
we understand your point. You take issue with Mr. Trimilek's letter. You take issue with
I take
our
issue with the
interpretation.
because I'm trying to point out that people are making errors, and I have the facts, and I can read it. I can see there's nothing in the ordinance, in 2022 ordinance, 2016 ordinance, that states that lot and that address is in C.
Yes,
Nothing.
I know, and
You
I've
don't
heard
even
what you
have
said.
meeting minutes. You don't have a notification to the
I've
public.
heard-
Nothing is given.
We have heard what
No
you said.
facts.
I understand. We've heard what you said.
So you can't, this is just, the property is null and void because of failures of this system. This property is null and void. And you're cutting me off, letting me read you the facts and tell the truth. And you all better rethink what you're doing here. And it's the residents that are.
Ms. Pickett, I think I appreciate your frustration.
No,
I do.
you don't-
No, I do. I do. Listen, I know that I'm a stickler.
You know what?
I'm a
You're the one that wants to say that the map rules. You have to have
Yes.
language. The law says, and Mr. Neese knows that, and Mr. Trimilek knows that.
I believe-
The law says you need language in an ordinance to change a map. You do not have it.
I completely respect your frustration. I believe we need rules of the road. I believe we need to respect authority. What does our board have authority to do? What do other governing bodies have authority to do? I do not believe we have the authority to overrule the zoning board's determination or the governing body, their determination. And I completely respect your frustration because the application is before us now, and we're the ones to make this determination whether we approve and grant relief to the applicant or not. But respectfully, I feel that I have to follow the legal precedents. I have to follow the ordinances. I have to follow the law.
But you're
This-
not following the law.
But that's.
But Ms. Baker, that's not for,
I understand you
you have
disagree. This
redress
is-
in other bodies. I'm telling you the reasons why I'm saying the things that I'm saying up here.
Would you like to comment on the application?
Yeah, I have a comment. My name is Levi Siegel. I live on 111 Edgemont Road. There's been a lot of discussion about, whether this conforms to the existing zoning code or not. I want to talk about just, the application in general and whether it is right to have in Montclair. I would argue that 260 Park Street is the perfect application for this site and represents exactly the kind of developments that Montclair should promote for the future. One crucial element that the planning board should consider for all applications is smart land use, to ensure that we are using the limited land we have available to meet our affordability and sustainability goals. A large portion of Ward 1, where this property sits, is zoned exclusively for single-family homes only. This is an environment where it is difficult to build affordable housing, and especially naturally occurring affordable housing, because the rules really significantly restrict what can be built on each lot. There's a very high demand to live in Montclair. We are a nice place to live, and especially in Watchung Plaza, residents live within walking distance to various high quality of amenities. There are restaurants, grocery stores, and other essential services. Watchung Plaza is so desirable because it is a space for people, not cars. You don't have to cross large parking lots and many lanes of traffic to access the businesses. The storefronts are accessible right from the sidewalk. This creates a human-scale environment that people want to be in. This is an environment that is convenient, aesthetical, and walkable, and it is where small businesses and community can thrive. And this environment is created from the same buildings as this site, a mixed-use building. And let's not forget that the nearby train station and bus access and that all the services are within walking distance. All of this means that new residents will not need a car to get around with transit access and walking distance to essential services. That's very important because there will probably be less traffic and people don't have to financially own a car, the financial burden of owning a car to live there. And reminder that this application explicitly includes subsidized affordable housing units and would be only one of few in Ward 1. I think there's only 2 in Ward 1, but there's over 500 in Ward 4. Everyone who wants to live in Montclair should have the chance to live here affordably and where they want to live in Montclair affordably. I really think this principle is far more important than concerns over suspected traffic or density issues. And many cities struggle to meet this kind of affordability goal. We desperately need more affordable housing, and because most of it's concentrated in Ward 4 by the Bay Street Station area. And this application it's an infill missing middle housing plan near transit, which is explicitly recommended by our master plan. It conforms to the surrounding area. It's 3 stories and mixed use, which is the same height as the Milburn Deli structure and surrounding homes. And so it really wouldn't be a stark increase in density. And yeah, it doesn't need any more variances. Plans like these are perfect for Montclair because they address affordability in a sustainable manner that would not be a stark or imposing increase in density. I just read a recent Pew Research article that highlights the ongoing costs to local governments and taxpayers to maintain infill housing. And they found that when you build new infill housing near existing jobs, stores, and transit, there's 50% lower property taxes per acre. The ongoing cost is 50% lower, and property taxes per acre are 13% higher on average when new homes are built near existing jobs, stores, and transit. In short, this plan is smart land use and can maintain a healthy amount of tax revenue compared to lower density areas. Thank you.
Thank you.
Good evening, Diane Moore, Winegast, 268 Park Street.
I couldn't
so
hear your name. I
It's
think-
Diane Moore, Winegast.
Okay.
And I think I understand that you understand what it is that the question was really. Does the ordinance say 260 Park should be adopted as part of the new map that you keep referring to? And I understand now that you understand that that is the question. Okay.
Thank you.
So that said, and then I think you said after that, that then goes to, if there's a question about that question, it then goes to another board, the zoning board, and they get to make a decision. Is that what you said?
They did make a determination that the property's in the
So
NC zone.
You didn't make that
Yeah.
determination?
We don't
You-
make that determination.
You didn't make that? So
Correct.
you
Correct.
give that to them?
We don't have the
Well,
authority to make
the
that
municipal-
determination.
Well, I understand that
Yeah.
you're saying that
The
they
state law
have,
designates
that they've voted on that already. That-
Correct.
But the
applicant-
resolution hasn't been printed yet, I
Yeah,
guess.
I'm sorry, the applicant requested that the zoning board make that interpretation after the denial by this board. I just
So
want to
if an
clear.
applicant gets an opportunity to speak before the zoning board about the reason to adopt what they would like to, how they want to interpret
No,
that ordinance.
that's not correct. They simply asked the zoning board to make an interpretation, not, they didn't say to the zoning board, decide the application the way we want you to. They asked the zoning board to make the interpretation.
Yes, and now the residents would like to ask the zoning board would like to know why they did that.
We're the planning board. This
So-
is the planning board.
Right, so you can't speak to why the zoning board did what they did.
Correct.
And
Okay.
I understand how frustrating and
It's not, you know,
confusing this is. 'cause-
with all of this talk about what this is zoned, we're, I think, forgetting the reason that zoning is so important as to which it is. Because one way leaves it as a home, and actually a two-family home, I believe. One way is a two-family home. Is that right? And another way is an apartment building and a commercial store. And the reason that that becomes such an issue is because of the extreme difficulties in that location to move around. Cars can't move around there. They just can't. They can't really back up or pull over or get somewhere because there's nowhere to go. So what keeps happening, obvious, is that it's constant. It's too hard. I've been away for a few months. I came back yesterday evening. I went out this morning. I couldn't really get out because I had to get out a different, kind of move over because the car was in the driveway. The back bumper was in the driveway of a car because they couldn't fit any further, I guess. And it took a while to get down to the corner. I see confusion where pedestrians are not sure if they should go or not go. It's a difficult situation. There was yesterday when I came and made a right to go home from where I was, a young boy was standing next to his bicycle looking around. He wasn't sure what to do, and I wasn't sure what to do either.
Same.
So there's a lot of things going on at that corner. And now I understand that there's been an approval for a convenience store to open up in that location, further confusing comings and goings and ins and outs. Truthfully, it sounds very crazy to me to add to that. Also, I was not aware, and I have a real estate license here and a broker in New York. I don't remember anybody ever telling me when I bought a property that I was guaranteed to be able to do something that I wanted to do. Yes, I agree. If you have to look at something, so you looked at the map and you said, okay, we can do this. I get that. And Gentleman D'Amato said, nobody's saying that you wouldn't be harmed if you couldn't do what you proposed to do. That I understand. That's true. And that, you know what? maybe it is a mistake to allow that. It would be a mistake because what it would do is bring more constant calls to police, parking authorities, constant worries about, is somebody going to get hit here, is all the time. It is happening all the time. So to go ahead knowingly saying, well, you know, it fits into the zoning that has been decided. It fits in it. They're not asking for a variance, so we have to approve it. But that's not the understanding. That's not the complete story.
But that's what we're bound by. But
if you heard what...
No, I hear what you're saying. I drive down there and I have the same concerns you do.
No, but
yes,
but you wouldn't knowingly say, okay, I know this is wrong, but I have no choice but to approve it. Is that what you're saying? I would like an affidavit.
Well,
yes?
I mean, I've said,
we know this is wrong to do here.
I'm not saying I know it's wrong to do there. What I'm saying is that this is why we spend so much time at all these hearings and even tonight trying to understand what zone this property is in, because I recognize it has a big impact.
Because of the questions about which zone it has been or is, that now comes to this point where the zoning board has decided it's NC.
Correct.
The board doesn't have any reason for purposes of variances to say anything further. But it's my understanding that just because something can fit doesn't mean it's proper and should be approved.
But if it complies.
It may comply, but it doesn't mean it should be approved. It is.
But we're not, that's not up to us.
But all you're saying is that then the board is constantly being, what's coming before the board is a constant proposal of setting up bigger problems that the town has to then deal with?
Yeah, well, we live here too.
So that's what you're doing. Our
hands are tied on a lot of these, and I hate saying that, and I've said it not just on this application. Yes. I've said it on other applications, so this, if you do follow the planning board, and I'm sure not a lot of people really do intently, but I've had to say this a lot recently, this year and in the past year, especially sitting in this chair, that I have voted for things that I don't like, and I have voted against things that I personally like, because we have to follow the laws, the municipal land use law and the ordinances of the township, and all the other things that are upon us. We don't dictate zoning. It's merely if an applicant comes forward and with an application that conforms to the zoning, there's not much that we can do. And that's, and
well,
it's
obviously,
If I may, if an application is denied by the board and the applicant takes that to court, the standard that the court will apply is whether or not the board's actions were arbitrary, capricious, and unreasonable. That's the standard that a judge will apply. Looking at this ordinance, looking at this situation, and I'm not telling what the board's going to do, I don't know, but if this application is denied and it's brought before a Superior Court judge, the denial, at least in my opinion, will be reversed.
That's your opinion.
Based on the law, based on the standards of arbitrary, capricious, and unreasonable.
Well, I don't think
that's
there's
the law.
anything, I disagree with you because
capriciousness,
that's not what this is about, because there are real facts, there are there are real issues with police, there are real issues here.
Yes.
This is not a made-up.
Yes. No,
photographs is,
yes.
You've got everything.
We have seen it.
And you've got a situation which
and
is
I need
still.
I need to let other people also comment.
Okay, so
Miss, I need to let other people comment.
Okay then.
You've been up for, I
Thank
think,
you.
at least 7 minutes.
Hi, hello. So my name is Axel Hellman. Can you hear me?
I'm not sure.
Okay.
Is the light on?
The light is green, yes.
Okay, now I can hear you.
My name is Axel Hellman. My address is 10 Columbus Avenue. I've never been to a planning board meeting or commented at one, believe it or not. I'm a little nervous.
I believe it because not a lot of people come here routinely.
So of all the perspectives we've heard on this project until now, I think one that hasn't been well represented is prospective entrance to the neighborhood and prospective entrance to the housing market. Meaning, anyone who might need an apartment someday. I include myself in that group. That includes many people in this world, young and old. So I went to Montclair High School, class of 2012. I can count on about one, maybe two hands, the number of my 480 classmates who are still living in town. Many of them haven't gone far. Maybe Clifton, Bloomfield, Hoboken, Jersey City. Many more of them would like to be in town, but they can't find places that meet their needs. There's demand to live in Montclair from both new people moving from outside and from the existing community, but there may not be the supply to meet that need. So yes, there are concerns about neighborhood aesthetics. There are concerns about traffic, but I want to point out that in the big picture, the population is increasing, the housing supply is not keeping up, and we need to build more projects like these for people to live in town. And if housing is to be built in town, probably the least impactful to the neighborhood aesthetics are mixed use and mid-rise apartment buildings like this. And then if we're going to put additional housing and businesses in the town, I think a good public policy is that they should be clustered near train stations like this one. So I think this is a good project, and more buildings are needed like this to meet the needs of the community. This concludes my remarks.
Thank you. Sir, I believe you already came up for public comment.
Those were questions.
No, we haven't taken questions.
You said I was very clear.
I said
these are my questions, not my comment.
Yeah, you did. You did.
I was very clear, and you were very clear.
I was very clear that we would
You were
try.
very clear that yes. You replied yes, yes, yes.
I
said, you said, I will let you have questions.
Can I respond now? I said I will let you ask questions as part of the public comment. I will let you ask questions. Yes,
That was not the understanding. I'm going to be more frank than I expected to be. Because I don't believe, frankly, that you have carefully read the 2022, which clearly refers to C1 Central Business Zone, clearly refers to C1 zone from 6 stories to 4 stories, clearly refers to 10-foot setback requirements, and has a map of Portland Place, Park Street, and Bloomfield Avenue. It is not an ordinance that passes a zoning map for any other part of Montclair. There's clear physical evidence which was presented at the zoning board that 260 has and always was been zoned as residential. No ordinance has ever been presented that changes this designation. Not since 1908. Mr. Tremelack cited Cox and Koenig, 2026, a legal reference to zoning and land administration, but a full review of Cox and Koenig reinforces that a written text is an ordinance. A written text is an ordinance that states the law, and that a map is merely an illustration. And our township lawyer, who is defending his opinions, said the Superior Court must decide the legality of all of this. And all the zoning board can do is look at a map that's in front of him, but the map is erroneous. And I believe that that was a move to avoid the issue and make the development of this a fait accompli by saying that the neighbors wanted to go to a Superior Court and spend thousands of dollars knowing that that would probably be an impossibility and it would be done before we could ever do anything. And why is the township staff suggesting that residents of Montclair bear the cost of legal legal challenges. Shouldn't Mr. Tremolak and his client have their facts together and show us the ordinance that truly designates this property commercial? A map is not a written and duly passed ordinance. And Ms. Talley, who also has a self-interest in protecting her opinions, cited the 2022 ordinance, but it's all about C3. It's not about our particular area of Montclair. She handed this to me in her office with the map of the C3 district at Portland Place, Bloomfield, and Park. Discrepancies and mistakes have been a repeated problem in Montclair over the course of this year, costing our residents thousands of dollars because the township lawyer misunderstood a law about sidewalks. Oops! 6 weeks later, after people have spent thousands of dollars, we made a mistake. That's what this committee is going to do? Oops! Should the township council and its committees represent the developers, which is what the previous council did? Or should this committee and the township council represent the residents and what they say, and not make things a fait accompli before a true legal decision can be made? If Mr. Tremolak and the developer wants a true legal decision, let them go to Superior Court by your saying, no, take a pause. Let's see what happens. Because I can tell you that we should sue the Montclair Township for the damages that it will cause us because of the traffic that you're going to cause in my area. Thank you.
Thank you.
Good evening. My name is John Wenz, and I currently rent at 132 Midland Avenue while actively looking to buy a home in Montclair. So needless to say, I'm very much in tune with the local housing market. I'm also active in Strong Towns, a nonpartisan national movement whose mission it is to advocate for cities and towns of all sizes to replace the existing broken system of policies and regulations with an approach that's financially strong and resilient while creating communities that are safe and inviting for all. Among our priorities is the issue of housing. Simply stated, we're in crisis. In a strong town, housing emerges rapidly in response to local needs, kind of market response. But across the country, our neighbors can't find homes they can afford to live in, and local businesses are prevented from helping them. To address the crisis, we must first understand that we're in a housing trap. Housing has evolved as an investment. Investment prices must go up, and housing is a shelter, a basic human need. When the price of shelter goes up and the availability drops, which is what's happened here in Montclair amongst cities and towns across the country, distress is the result, and that's what we're feeling here. We've got to address the regulations that block traditional responses to housing needs. Building anything other than a single-family home on a large lot involves a long, expensive process, and I don't have to tell you folks that. It's a huge barrier for those who'd like to add housing in a way that fits the neighborhood. What we need is called the missing middle, and it refers to a mix of medium-density housing types such as duplexes, townhouses, and small apartment buildings that easily blend into residential neighborhoods. We already have some of them right here in Montclair. They were historically quite common to build here, and they still are in other parts of the world. But they became illegal to build in this town, like most of the country, due to zoning laws that prioritize detached homes. We need to take a close look at this, at the missing middle, and see how it fits into our future. Here in Montclair, we not only have a shortage of housing, but property taxes are reaching an untenable level. Since residential property taxes provide the largest portion of our town's revenue, you can see the connection. Something's got to give. The time has come to take a close look at the obstacles in the way of projects such as the one in question. While I understand and empathize with the concerns of those residents and property owners in the neighborhood, I feel it's imperative that you approve this project. Approval will send a message that Montclair is adapting to the realities and the challenges of today and tomorrow, which were created by policies and decisions. Most were well-intentioned, but they were made in the past. Thank you.
Thank you. Any other members of the public?
Jay Turner, 274 Park Street. I don't know what I'm going to do with my Monday nights when I'm done with this. So a lot of nights here.
You don't want to come back and hang out with us?
We'll have plenty more meetings.
We're here twice a month.
We will. So.
Please do. It's a fun night.
You know, I first came to Montclair in 2006. I thought it was one of the most beautiful towns I'd ever seen. It seemed like a very special place to live. It was voted a white picket fence town, I think, last year, one of 50 communities in the Northeast, most desirable places to live. They cited our old homes, our safe streets. You know, I assume all of you, I know some of you, I see you all the time about town. I assume all of you guys live in Montclair. Is that a correct assumption? Yes?
Yes.
All of the,
Okay.
Well, I do.
So,
all the Class 4 members have to live in town.
okay. So,
Certain folks can be designated by the mayor, I believe, who may not be in town. But I believe everybody here is in town.
okay.
Just
So,
technicality.
So, Mr. Graham, you made a comment, you know, you said when a developer buys a property and it's shown on the map, you know, you don't see how it would be unfair. You know, he's looking at the map. Obviously, that's why he's buying the property. He thinks he can do something with it.
Well, that's
It's-
one aspect of it. I think
Yes, sir.
also, if
yeah.
it were to go to court, you have the danger of awarding damages to the developer, who then will be able to build the property anyway, so we lose twice.
I understand. I think in this case, no matter what happens, there's harmed parties. I think we could probably all agree on that, you know. So either Gino or us, you know, somebody's not coming out good here. I just, and to your point, I just want to say this. As soon as I found out that 260 was theoretically zoned commercial, it blew my mind. I mean, I'm assuming if you live here, you've been over to the hardware store and seen it. On one side of Park Street, the zoning ends at the hardware store. 260 is at least 100 feet past that on the other side of the road between two residential houses that are 120 years old. I don't think any objective person that you just took over there and pointed and said, you think that's a resident, no one would think it was commercial. So I would say that there's some level of common sense and due diligence that would have to go into this. So yes, if I was buying that property and I was a developer and I saw on the map that it was marked commercial, I would be questionable of that if I actually physically looked at the property. This seems too good to be true, would be my thought process. And so to that point, when I heard it was zone commercial, I called the planning department and spoke to Richard and asked him, when did this become commercial? He said, I don't know. I'm not looking it up for you. I'm not going to waste my time, and this is going to pass. Then when I was in here, I asked Ms. Talley. I said, when did this become a commercial property? She said to me, we don't have records for that. My response was, you don't have records for that? She goes, that's right. And if you think our town's bad, you should see other towns. So it didn't seem like there was a tremendous search for the truth here, or what the actual zoning was, which is confusing as a citizen of Montclair. I would think at the end of the day, everyone would want what's right for the town, especially when there's going to be a harmed party in the end. We'd want to get it right? Because it's not just for us, it's not for me. I mean, I'm 61. Hell, how much longer do I have? But I mean, this town's old. There's going to be people on for another 150 years, 200 years. You've got a beautiful street of historic homes, and then you go down there. Personally, I don't care if Gino builds an apartment complex there, as long as it has a historic look. And by the way, everywhere else in town where there's a historic, there's apartments that integrate with residential buildings, there's no stores on the first floor. That's one of these things where you pass an ordinance because you want to have walk-up traffic, I guess like they have in the city, and overall it's a great idea. But there's always an unintended consequence. So here we are in the middle of a residential neighborhood, and Gino's going to put a bagel store. A bagel store that's literally going to be within 8 feet of somebody's porch. It's insane. I've never seen it anywhere. That's nuts. There's no buffer. There's no buffer zone. You're going from a bagel store. Uber drivers are going to be parking in Elchie's driveway all day long picking up orders. Nobody would want that. You wouldn't want that. You wouldn't want that. Nobody would be okay with that. The people that came up here and spoke, I've never even seen them before, and they sure as hell don't live anywhere around me. So maybe that was your uncle that was just up here, Gino. I don't know. But anyway,
Well, but
point
every resident is entitled to make a comment.
The point is, no one would be okay with that. It doesn't make any sense. It doesn't look right, and it harms our community for decades, if not centuries, to come. My thing would be, I don't care if the man builds an apartment complex. If it's in keeping with the look of the neighborhood, it has more of a historic context, and there's no store on the ground floor. We literally can't support it. When they open the Westerly and the Milburn Deli open, we get hundreds of Uber drivers all day long that are parking on the street. And they park in front of your driveway, or they double park on the street because they're only going to be there for a few minutes. It's chaos.
If you could wrap it, you're well past 3 minutes, quite honestly. But and I hear what you're saying, but
yeah,
if you could just
the crux of it is
wrap it.
It's very harmful to our town. If it does get approved, it would be nice if at least, like as I mentioned before, you could put the bagel store on the other side of the building so that the driveway is on the residential side. There's some kind of buffer instead of just having bagel store. Hey, y'all, chief, want a bagel? I can hand it over
And
to
they
you.
said they're not going to do that.
Then that's unfortunate. That seems like you're not working with the community. So.
I hear what you're saying.
All right. Well,
Yeah, and we've hashed through a lot
and
of that
I would
in the past
respectfully.
hearing.
I was here for the zoning meeting, and they canceled
But
the meeting
you're-
at the
you're-
last minute and wasted my time because there was people missing,
So-
and they didn't want to vote. So why would we vote tonight when Mayor Baskerville's not here and another member's missing?
Because we can't hold off and not vote because people aren't here.
Well, then how did they legally do it for the zoning?
I don't
meeting?
know how the zoning board operates. We can't do that. I understand.
It feels.
Like,
I mean, respectfully, it feels kind of like the fix is in on this one.
I understand.
All right.
I disagree, but I understand.
Hi, everyone. My name is Carl Nagy, and I live at 109 Buckingham. So I live not that far away from this project, and this is probably the fourth or fifth time that I've come to talk and listen in front of the planning board and zoning board about this project. I think this is going to be a good project for our neighborhood. I think we need more buildings like this in Montclair, and we have a total affordability crisis that is just walloping people. I've talked to people who live in buildings very similar to this. They're paying rents very similar to what these residents are going to be paying if we approve this. And these rents are too high, and they're objectively too high. But if you actually talk to the people who live in them, a lot of them cannot afford to buy a single-family home. A single-family home on that block, and where I live, and all over Montclair, they cost $1 million or like way more than that. And if you look at the monthly payments and tax on a single-family home now, it's $7,000 a month plus $200 down. So these people, I talked to a resident who grew up here. They're like 3 other people in our building, grew up here. This is where we could live. We have a young kid. Who knows if we'll be able to stay forever, but we're going to live here for now. And that was across town. But that's the story that's not getting told a lot of these hearings. And I could actually take or leave the pizza or the bagel restaurant. I'd actually be very much in favor of adding another unit instead of that bagel restaurant. Amen. But I really, really hope, I'd love to do a petition to allow on the edges of some of our commercial districts, maybe we can have some more housing instead of some additional commercial where it makes sense, but maybe not right in the middle. But so I really hope we approve this. And the other thing I'll say is, I really am disappointed in the process that we've gotten to from now. This application was put in July of 2025, and we're in June of 2026. I've been to 4 or 5 hearings myself, and I think it's 6 or 7 total. And I was disappointed in the vote to not approve this before. I disagreed with that. I'm not a lawyer, but I was disappointed. And I think every time we delay, everything needs a fair hearing. If something's wrong, it's wrong. Give them a quick, fair hearing. But when we delay, it adds a cost to our township's tax dollars, and adds cost to all the building. It's just more expensive. And I've talked to people who want to build, and it's apparent, this process has been chilling. And that's just harming us. So I think we all also know that if we don't approve this developer is going to sue, and they're going to win, and we're going to pay a lot in our tax dollars. And I think that'll be really sad. Now, if we approve it, maybe certain residents, if they want to put out of pocket, I think that will lose and probably a waste, but I don't want to pay my money for this. I don't want to pay any more of our tax dollars for something that we're going to lose on too. So I think it's a great project, and I'd love to see a streamlined process and figure out collectively how we could do that. And I hope you vote to approve this project. Thank you.
Thank you. Any other comments on this application from the public? All right, I see none. Well, there's my 3-minute timer. Okay. Thoughts from the board, or any other additional thoughts from the board? I think we probably have gone through this a fair bit. We've heard a lot of the residents' comments. Any last things that anybody wants to say or do?
Just repeat, I mean, it would be good to have the absolute language of the resolution from the zoning board. I think I've heard a couple of versions of what was actually decided. And the main difference is, what I heard was, it's on the 22 map. I did not hear that the zoning is absolutely NC. So, and that's a big difference. So I think that getting the actual language that comes out of the vote of the zoning board is critical to our decision. Otherwise, there's a little bit of hearsay about what did they actually vote on. I watched the video, my interpretation is this. I mean,
Mr. Tremblay,
I'm
what is the
prepared to vote
draft?
tonight.
Do you have the draft resolution you stated? What does it say in the draft resolution that could clarify?
It says a lot of things that are helpful, and it's also important to note that most of the people here who are objecting to this were at the zoning board meeting.
Does it state that
Ms. Pickett's
260 is...
attorney was there and presented
We
everything
know.
which she says debunks.
Mr.
Does
Tremblay,
it
we know.
state that 260 is in the NC zones
Yeah, clearly.
explicitly? Can we just read that into the record then, if you have it? Sorry to spring that on you.
Bearing
No,
in
it's okay.
mind that it is a draft, and it has not been yet adopted by the zoning board.
Right, but I think it would help to add some clarity to this
I understand.
conversation.
I just
Yeah.
want to be on, just that we note for the record.
Yes.
It's
Yes.
not adopted.
I believe it's on the agenda for Wednesday night.
It's going to be adopted in 2 days. I'll start with the board's conclusion or finding. Be it resolved by the zoning board of the Township of Montclair that the 2002 zoning map depicts the subject property in the NC zone. Early on, and this is really relevant, there's a lot in here that's relevant to the conversation we're having here, you know, because this was discussed at the meeting, and there's a finding that courts have held that land use boards have no jurisdiction to determine legal issues which are solely within the jurisdiction of the courts to decide, such as the legality of an ordinance, citing a 1950 New Jersey Supreme Court decision, Fisher versus Township of Bedminster. The remedy for an interested party that asserts that the zoning map is inaccurate due to a clerical error is to file an action in the Superior Court of New Jersey or to seek an amendment of the zoning ordinance and zoning map from the governing body.
So the governing body, to clarify, they don't have to go to court, they can go to the governing body and request an amendment. Okay, so that could save
But the
legal
fundamental
expenses.
thing here, which I keep harking back to, and I don't want to belabor this much longer, is this board, neither this board nor the zoning board has the legal authority to simply say an ordinance is invalid and we're going to disregard it. There's no right to do that.
And to clarify, the town council can make that amendment. That's the governing body we're referring to.
Yeah.
Okay, I just want to make sure that everybody has clarity on that.
And the other 2 points I just want to make briefly in response to what we've heard from the neighbors is everyone's talking about the 2022 zoning map, and that doesn't refer specifically to 260 Park Street. No zoning ordinance adopting a zoning map really specifically refers to properties, number one. But number two, as we know earlier from the discussion, Mr. Inawali mentioned it, the 2016 map is the same, so there was no change between 2016 and 2022 that affected 260 Park Street, so there wouldn't be any reference in the 2002 zoning ordinance to 260 Park Street. The other thing, everybody, there's the flaw in this argument that's being advanced is people seem to think or accept that this property, 260 Park Street, was originally zoned residential. There's no proof of that. What we have is, we have Janice Talley's memo saying, I've looked at every zoning ordinance since 1974, and they all show the property as being an NC commercial. And people said, well, we never, has anybody come forth, nobody's come forth here or before the zoning board ever to show that 260 Park Street was originally zoned residential. Again,
the resolution isn't even in print yet.
Now-
You didn't read that. You just read a piece of that. The resolution should be done before.
I think that's where Mr. Ian Wally's going with his.
Pieces that you want to read. Why don't you read the whole thing?
I'd be happy to read the whole thing. If the board feels that's
again,
important to see
Mr.
the zoning board ordinance's resolution.
I read the pertinent part. It said, and that's what I heard when I listened to the zoning board meeting, that the resolution is that the property is shown as NC on the 22 map. It didn't say the property is absolutely zoned NC. It tells us what we know already. It's on the 22 map as NC. So if that is the conclusion, it really adds nothing to this process.
That's not true.
I believe it does.
It's not true.
Well,
they did an interpretation. That is their conclusion. So,
but the conclusion is that it's on the same map that we
this process is simply to
looked at.
enforce, as I keep saying, this process is simply to enforce the ordinances of this township.
Okay.
And right now, the 2022 map was adopted by ordinance, and I know people disagree, but the fact of the matter is that it's still of record as being in the NC zone. And if the board doesn't want to accept that, well, you don't have to, but I think it's wrong.
Well, I didn't want to advance a conversation about what happened at the zoning board much further, but the neighbor's attorney attempted to engage the zoning board with some facts, with some maps, with some information, and the zoning board effectively turned a complete deaf ear to what was being said at that meeting.
The zoning board applied the law, which is that they don't have authority to make legal determinations.
But regardless, we're not in a position to question the outcome of the zoning board's decision. That's not for us to decide. That's the only court redress, as Mr. Tremulek stated, to question their decision is in a court. The map itself can be brought before the township council for an amendment or go to court. There are two options there. We are not the appropriate body. We do not have the authority to question the zoning board's decision there, their determination.
That is correct.
It's not our authority.
That's correct.
But their decision says that it's zone. It says it's on the map as this zone. From my read, it doesn't say it's absolutely zoned NC, despite the fact that errors have been pointed out in maps that it presented to us.
So their conclusion is that it's in the NC zone.
Their conclusion is that it's on the 22 map. That's what I read, and that's what I heard. But let's see the resolution.
But doesn't the 22 map show it in the NC zone?
Yeah.
Right, so
I watched the meeting pretty closely, and for me, it was unambiguous that the Board of Adjustment was concluding that it was in the NC zone. I mean, maybe there's some real Talmudic hair splitting. I'm not really sure where you're going with that part of it, because
what he just read said it was on the map. It did. Again, I guess. Well, okay.
It's on the map, right? Yep.
It's shown on the map.
And the map shows it in the NC zone.
And the map shows it on the NC zone, despite the fact that we believe, well, some of us believe that there are, and there has been interest from the public that this zone of NC is incorrect. And I've been hearing a lot about that. We've looked at historical maps. I found errors in the conclusions that people have made from the historical maps. So I'm just trying to filter the information adequately and accurately as possible so I can make a vote.
Tony,
And
I think
that
there's a case.
having a written resolution, if what the zoning board is impactful to our decision, isn't it reasonable to get something in writing from them?
Well, I think we have the draft that gives us the information that we're going to get. I don't know it's going to get any clearer from that. But I think there is certainly a case for us to have an ad hoc committee involve the public and do a review of the zoning maps. And I think we should implore the public, let us know if you think there are errors. And I think we have a communications committee. This might be the opportunity to use it and to let people know so that this doesn't happen again in the future. I think we're too far down the road on this one. I think this decision has been made, and we don't have the authority to question the zoning board's decision on this. But let's get an ad hoc committee together. This is clearly important to the public, and we should take the lead on that and be leaders and say, hey, we need to review these maps.
Well, you avoided my statement was, isn't it reasonable that we should have the decision from the zoning board in writing?
But I think we have the
First,
language that we're going to get. I mean, I think we can rely that in 2 days it's not going to change so substantially as to change the meaning of the draft ordinance. I would wager.
So, I mean, is that what I'm hearing, is that the board or certain members of the board want a copy of the resolution before making a decision?
I would prefer.
Prefer it?
Yeah.
I mean, is that hold on, we're not taking comments
Yeah,
right
I
now.
was responding in the affirmative. I would prefer to have a final resolution in hand, yeah. It's my preference. I mean,
is that something we can wait for? I mean, I don't personally think it changes anything, but I'd rather not force people to make a decision if there's missing information.
I think I'm going to agree with your earlier statement that nothing in that resolution is going to really change appreciably or materially from what the zoning board determined. So
Can we, if we were to make a decision this evening, can we condition it upon the zoning board resolution memorializing their earlier decision? I don't know if it's not a condition on the applicant, but it's just
I would not advise going that route.
Okay.
I understand where you're going with that, but I
Okay.
would not advise doing that. There's no basis to do that. The board has before it the application that you've heard over 4 meetings, and there is a representation both by the applicant's attorney and by me that the zoning board, because I listened to it, and I'm not here to interpret, but I'm reporting to you what I heard. I don't think it's going to change by getting a memorialized copy of their resolution. So I think there's sufficient evidence before the board for it to make a decision on this application tonight.
slightly different question. Maybe it's for
Chairman?
Arthur.
Oh, go ahead.
Sorry. I'm curious, is the mixed-use designation permitted or is it required? It is required.
Yes. Otherwise, I think if I remember the testimony correctly, if they eliminated the commercial use, they'd have to go to the zoning board for a use variance to put in only multifamily. Is that accurate, Mr. Trumbull? Okay. That was my recollection from the testimony.
We can't compel them here.
I mean, we have to decide what's before us. I know. It puts us in a tough spot a lot of times. And a lot of the applications we've had, in the past year or so.
What I'm hearing from the public sounds like that might be amenable.
Yeah, I agree, but that's not what's before us.
And we can't
Right.
presume
And
that the Board of Adjustment would give the variance.
Right, and
Sure.
we can't compel an applicant to go somewhere else.
Yeah.
They made an application, it fit the criteria to come to the planning board, not the zoning board, and it's for
where
us
we
to make
are.
a decision.
Yeah.
As challenging as it is, and given all the facts that we've heard, I think it is a challenge, but we're
here.
obligated by law, by the oath that we took, to decide applications based on the evidence that's before us, and we can't, we've had other applications where, we've maybe suggested some changes, And other applicants have said, no, this is our development, this is what we propose, make a decision. And that's what we're obligated to do.
All right, let's do it.
Chairman,
Yes.
can Mr. Neese just outline how we got back to this discussion?
I'm
How
not,
did we get back here after the vote on March 9th?
After making a decision at this body.
the applicant was not satisfied with the board's conclusion. And therefore, because the board's decision appeared, and I can't speak for Mr. Trembulac, but because the board's decision seemed to be based, the denial seemed to be based on the contention that the map was wrong, and several people voted on that concept, the applicant determined to take itself before the zoning board for an interpretation of the map to determine whether or not the conclusion or the contention that the zoning map was wrong was wrong. The zoning board determined that the property is in the NC zone. With that, the applicant comes back before us and says, can you guys reconsider your decision based on the zoning board that has the authority under the law to interpret zoning regulations? Can you guys reconsider your decision?
And what language did the board secretary get from the zoning board for us to have this hearing today? What notification did the board secretary get from zoning?
The applicant, after the zoning board determined its interpretation, the applicant re-noticed in a public manner this meeting. They sent out notice to people within 200 feet. They published notice in the newspaper and online, and they requested through that process to get before us tonight.
And was the draft resolution attached?
Of the zoning board's resolution?
Yes.
No.
No.
There was no communication from the zoning board of adjustment to the planning board on this matter.
Okay.
So we don't have it.
Thank you. Thank you.
You're welcome. Any other questions, thoughts from the board? Looks like no. Well, I think I was probably the one to move this last time, so I might as well move it again. Despite my reservations that there are, that I think there are probably some issues with the map, I think the fact that this property is in NC on the map, and the zoning board appears to have confirmed that, confirms kind of my initial thought on this matter, that it is a conforming application with no variances. There are some design waivers that I think can be granted. And so I would move approval of this with the conditions that we discussed already this evening.
I second that, and I would just reiterate that this board, we don't have the authority to overturn the judgment of the zoning board or of the council. And I respect everyone's objections to this application, but we are obligated to follow the law.
Okay.
One more question.
Sure.
Yeah, thank you. Is there a world where we can re-look at the non-residential component?
We are already doing that as
I
part
know
of the
we moved
master
from
plan.
pizzeria to
No,
gate.
as part of the master plan reexamination report and anticipated zoning changes, I've had discussions
Oh.
about that. But that's not pertinent to this
a future
application.
condition.
That's
Yeah.
for future zoning changes.
Got it.
So you're saying that there has to be commercial?
Yes.
I'm looking at the NC zone. It says, permitted non-residential uses other than office uses occupy the first floor along the street with a depth of at least 30 feet. A residential lobby may also occupy the first floor frontage. It doesn't say that they must occupy, it says just the verb occupy. It doesn't seem like, if you read that literally, that there could be, you certainly can't put.
Is a multifamily building a permitted use? I don't have the zoning in front of me.
Well, I'm looking at NC.
If you're looking at the permitted uses, I don't believe it says multifamily is a permitted use.
Well, it's a mixed-use building that meet the following requirements.
No, mixed use is commercial.
Mixed use must
I'm looking at
include.
the NC zone, is that not
No,
where?
I think that the definition mixed use means residential and commercial together.
Yeah.
And I think that's what Ms. Talley is saying, is that when it says mixed use is permitted, it doesn't say multifamily reresidential or residential only is
Oh, I'm
permitted.
sorry.
I think is what Ms. Talley is trying to
Do you have
say.
time for me to look at that really fast, just to, because I think that's a good question. It's in definitions.
Hopefully. We're not taking public comment anymore, I'm sorry.
And I have to look up, I'm sorry, mixed use, right? Mixed use building, a building that contains both residential and non-residential uses. So if you put those
Is there a
two.
definition of non-residential? Is it
me see.
implicitly commercial, or?
It can be retail, it can be office.
It doesn't, it
non-residential.
doesn't
But
say,
is
no,
there
it
a-
doesn't define it.
Is there not
As a
a?
condition, sorry.
One
Okay.
at a time.
Go ahead.
No, Ms. Wallace, if you're still going, just go ahead.
My curiosity in the context of the conditions that we were
Mhm.
describing, we've moved from pizzeria to bagel shop. Is there a world
Correct.
where there's something that's more passive that, no?
You mean a more intensive use? Less intensive,
Less
excuse
intensive
me,
use
yes,
that
yes.
still
Sorry,
strikes
it's
as
now getting
non-residential
late.
and commercial, so I don't want to make suggestions, that's with the, yeah.
I mean, if the applicant wants to change it, I don't,
I think that's
he's
what
not
they-
indicating that he wants to, from a bagel shop to something less intensive. There may be, I don't know. Off the top of my head, I just don't know.
Well, it sounds like there must be retail. I mean, I just wanted to read this just to. see what the
I'm
zone
trying to
code
make
says.
sure everyone's, at least is heard, right? Whether folks agree or don't agree on the board, the public, I just want to make sure at least people are heard, and still try to get through what we need to get done.
It should be said, this is an application that started as non-conforming, or it had variances, and it is now fully as of right. It really is we do not deny, you cannot legally deny an application in the same way that if somebody buys a plot of land and they want to build a house. You can't just say you can't build a house. You can't do it. What we had is the power to withhold approval when they were asking for things, but the applicant isn't asking for anything anymore. They're just it is a pro forma thing, so that has to be divided, the two things, and the alleged miszoning, and I will still use the word alleged. You can call me a 260 truther, I'll probably die one, but it is, the fact is, it hasn't been proven. It is our belief, but it hasn't been proven. But separate the two things. If it is zoned correctly, it is an as-of-right building. And I personally feel like I've pushed this very hard for months, and I don't want to pin it on the zoning board or something, but there was a process and it went somewhere. I thought we took a risk once and defied a lawyer that I hold in high esteem once, and to do that a second time, it's a little hard for me, especially when I think of the actual practical outcome of this, which is the same building plus an award of damages to the applicant. So you're going to get your building and a higher tax bill, as somebody else said, and it's disappointing, but that is, where I feel like the sensible place is to be. We could wait another meeting to see, but I watched that meeting and they did not address it. And I feel like lucky to be, as a taxpayer, to get out of here if Mr. DeSanti has been very patient and does not try to get us for these delays so far. But certainly on a practical matter, if we deny now, I think it's pretty clear that we don't really have a leg, especially because it's not asking for any variances.
So we have a motion and a second.
Does anybody else want to be heard? I know, I keep going back to it, but I feel like, sorry, just put me, if you want me to stop, I will. But I just want to make sure that folks have a moment to ask any other additional questions. And you're right, we do have a motion, we have a second. So hearing nothing else, let's call the roll. Please.
Mr. Campbell.
Come back to me.
It's tough to be the first one.
I know. I go alphabetically with you last. Councilor D'Amato.
I'm going to have to vote yes. I'll vote yes. It's a law.
Mr. Graham.
Yes.
Or Vice Chair Graham.
Yes.
Mr. Ian Wally.
No.
Ms. Gaines.
Chairman, I would like to say that I appreciate all the residents who have come out passionately and spoke on the pros and cons of this application. I would also like to commend one of our interns from Complete Streets, which is Levi Siegel, who spoke so eloquently in regards to the affordable housing piece of this application. There are many, many issues with this application. At this time, there is nothing legally binding me to deny this application, and I vote yes.
Mr. Campbell.
No.
Chair Brodock.
Yes.
We have 4 yeses.
4-2.
Thank you very much.
Okay.
Thank you for all your time and consideration. I know it wasn't easy.
All right, so in case anybody came late, we're not hearing application 2959 for 116, 118 Walnut. So we're going to take a 5-minute break, and then after that, we will have application 2971, 427, 429 Bloomfield Ave, the living room at Montclair, which I assume is you folks in the back. Yeah. So we'll take a 5-minute break, and then we'll have you up.
reasonable
I'm
changes.
talking about those applicants. Hopefully, they're good neighbors.
All right, everybody, we've got another application to hear.
There needs to be more enforcement on that block, I agree with that. Make it harder, yeah.
No, make it speedy. Yeah, no, people left once I said we're going back on the record. Now 2 people left, so we'll be back momentarily.
Yes, July 20th.
Yeah. July 20th, yes. Yep. We're waiting for one more. As soon as I announced we're going back on the record, folks left. So we're just waiting for one more quickly here. Thanks for your patience this evening.
Of course, that was fascinating.
I'm glad you enjoyed it.
I'm second and third on the agenda all the time, and usually I just hear about variances being requested and, setbacks, and not usually that, so much more interesting.
I don't know. That might have been the second time I've heard something reconsidered on this board, but it's not often that happens. But certain times we need to do those things.
Since you feel that way, I think you should come back every month.
As long as I'm not paying. Very expensive night for me, but that's okay.
Didn't I do a good enough job of convincing people to come back, twice a month, Monday nights here?
I'm done with the interesting stuff. What is it? It's the Chinese curse. May you live in interesting times.
I don't even know it. No, I find this process as a planning board interesting, but I know not everybody does. And as I've said to other people before, I've said actually up here before, it's taken me 10 years of sitting up here to really feel like I understand a little bit of all the different laws and the different boards and the different, council and how everything works together. And so I feel for the public, because it's hard to understand, and only sitting here for years and being forced to be here twice a month at least, have I really started to understand it. Okay, now we have everybody back, and sir, this is the application for 427, 429 Bloomfield Ave, the living room at Montclair LLC.
Mr. Meyer, can you move that mic closer to you?
Is that better?
And maybe just turn it on too. There.
That would help.
That's much better. Much better.
Okay. Good evening. Thank you all for hearing us tonight. My name is John Mayer from the law firm of Stevens & Lee, representing the living room at Montclair, LLC. This prospective tenant of approximately 6,700 square feet of office space at 427, 429 Bloomfield Avenue, also known as the Madison Building here in Montclair, Block 3205, Lot 2, located in the C1 Central Business Zone. There's no one here to say it's not, so hopefully that's beyond dispute in this application.
I wouldn't. Yeah, I don't know about that. So that's your representation.
That's true. I'll say no more. We are here for a minor site plan with variance relief. My client intends to operate a behavioral health services center Focusing on mental health at the property, crucially, this is a permitted use in the zone. The only reason we're here this evening, because as I have gathered, this is a common issue here in the township, is parking. The property has no on-site parking, and pursuant to Montclair zoning ordinance, a medical office, which is what this has been deemed as that type of use, is more parking intensive than the current use, which was an educational play center and professional office space. Thus, we're exacerbating the existing nonconformity, necessitating variance relief. Specifically, the prior use would have required 31 parking spaces. The medical use requires 45 parking spaces, a difference of 14 parking spaces. As I said, we understand that parking's at a premium here in Montclair. However, based upon the operations of my client, which you'll hear about this evening, we believe the variance can be granted. You will hear specifically from Dr. August Lemming, the CEO of the living room. I also have the COO, Nakali Jones, here in case there's any other operational issues that she might be able to opine on. And then lastly, and we're going to try to do this quickly enough that we can get to them, we have Justin Taylor, a professional traffic engineer from Dynamic Traffic, who has prepared a parking study for our property to speak about why this variance can't be granted. So without any further ado, I'm going to call my first witness, August Lemming.
Before you do that, Janice, do you have the exhibits?
Yeah, I pre-marked the exhibits. A1 is the application. A2 is the certification of taxes paid. A3 is the proof of publication. A4 is the affidavit of service. A5 is the survey prepared by Thomas Stearns dated July 24th, 2015. A6 are the architectural drawings prepared by NKA and dated October 24th, 2025. A7 is the parking study prepared by Dynamic Traffic dated June 4th, 2026. And A8 is the planning report dated May 7th, 2026.
Mr. Mayor, NKA, do you have the address? What is that?
They're an architectural firm. I do not have their address, but I can get that for you.
Yeah, it's not on any of them, and I tried to look them up, see where they're from, and I couldn't quite figure it out.
Yeah.
So if you could send that to me, I'd appreciate it.
Certainly. Oh, I can give it to you now, sir, if you prefer. Okay.
Yes.
I have a quick
Let him,
Oh, sorry.
he's going to read into the record the
Yeah.
address of
Sorry.
NKA.
It's 95 Washington Street, Morristown, New Jersey, 07960.
Thank you. Mr. Ian Wally.
Ownership LRC the applicant is the tenant.
Correct.
So the variance goes to a tenant, not to an owner of a building? I'm just wondering, isn't the ownership of the building normally granted a variance for the uses in the building that they own, or?
Yes, but the owners consented to this application.
Okay, so he's just tagging it, okay, so whatever happened, got
I mean,
it.
think about the cannabis retail shop that came
Okay.
before us.
Okay.
That LLC did not own the building. They
Okay.
were a contract tenant of the building, and they
Okay.
came before us to
So-
get a conditional use permit.
The variance will attach to the property
Correct.
to the benefit of the owner, and the tenant is testifying to the use.
Yeah, and you
Okay, got
can
it. Got it.
ask this gentleman, and questions like that. Once he's sworn in, of course.
Oh, and just before Mr. Nice, can we confirm that service is proper?
You would hear about it if it wasn't.
Okay, good. Just like to have it on the record.
Okay. Getting back to NKA, is that their full name? NKA?
That is correct.
Not NKA LLC, NKA Inc., NKA by John Doe?
I will get back to you on their incorporation status.
Okay.
Very expensive, I don't know whether.
This is a very expensive evening for you, I get that. Just raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Would you please?
Using the microphone in front of you, which you may have to turn on. We'll see.
Yes.
There you go.
Yes?
Now
it's
I
on.
hear you.
And then
Good.
Mr. Neese will ask you questions.
If you would please state your full name and your business affiliation for this record.
I am Dr. August Lemming. I am the owner and the founder of the Living Room at Montclair.
Okay, great. Thank you, Dr. Lemming. So just first, can you introduce yourself to the board, let them know your professional credentials, experiences, et cetera?
Okay, quickly. Yes, I have a PhD in counseling psychology from Seton Hall University, undergraduate degree from Columbia University. I currently operate and own the Living Room at Princeton, which is a facility providing the same services located on Route 206 in Princeton, New Jersey. We've been in business there for 4 years. What we offer is, and I don't know how important this is to the board, I don't want to waste your time by explaining or overselling the uniqueness of our deliverable, but the least unique element of what we do is my facility in Princeton was designed by a Disney Imagineer. So we operate the most elegant boutique facility in the country, to my knowledge. I also don't know of any other facilities in the state of New Jersey that are owned and operated by a single person who happens to be a PhD in psychology with 25 years of practice and 26 years of sobriety. And perhaps more importantly, I got sober in Montclair. And so one of the reasons I came to Montclair was to connect with the roots of my recovery at St. John's and St. James Church were the first AA meetings I went to when I got sober 26 years ago. And so I just was called back to this area. I grew up in Belleville. Prior to opening the Living Room at Princeton, I was a consultant. I traveled internationally as far as Doha, Qatar, New Zealand, the Philippines. I was a consultant to the U.S. Olympic team. I developed a model of performance enhancement that was compassion-based performance enhancement. So it was a model that helped people elevate the output in their lives using loving kindness as the motivation. I've been studying Buddhism for 37 years, which I started at Columbia University when I was 18 years old. So the model that we follow is largely informed by Buddhism, which is not a religion, it is a psychology. So it's rooted in mindfulness and presence and in compassion. One of the unique things that we do differently is that we don't treat people like they're sick. The suffering that people walk through the doors with when they come to the living room is an invitation for them to elevate their understanding of what it means to be human in a way that most people will never experience. And so we call them members. We don't call them patients or clients because we feel that they're blessed. And we use that opportunity to meet them from the very first second they walk in the door with an energy that they've not experienced before. So what we do is very, very unique. We are an out-of-network provider only, so these are people who carry professional insurance. We do offer scholarships for folks who can't afford our treatment. But the model is designed for a certain level of curiosity that not everyone walks through the door with, but when you walk into the doors of the Living Room at Princeton, for example, and you're greeted with a room entirely decorated with Wizard of Oz memorabilia, you kind of get curious, like, why is that? This is not what I would expect. And then you walk into my office and there's a secret passage that leaves my office into the main room, which we call the Great Room. It affords people just a moment to break away from the story that they tell themselves about the nature of the reality, and that curiosity is usually enough to get people interested in what it might be like to learn how to love themselves exactly as they are. And that's what we do. It works remarkably well in Princeton. I am very confident it will work even better in Montclair.
All right, thank you, Dr. Lemming. And now for the kind of the nitty-gritty, just for the board's benefit, when are you going to be open for your services?
We will have our longest program will be 9 a.m. to 3:30 p.m. That's called partial care. It's all outpatient. Folks will then leave at 3:30. A new batch of folks will come in from 5:30 to 8:30. 5:30 to 8:30 is only Monday, Tuesday, and Thursday evening. Just as a note, I parked in the garage directly behind our building this evening. There were 275 open spaces at 6 o'clock, of which we would, at night, likely only use 25.
Yeah, so just going off that, how many patients and staff do you anticipate having?
I mean, at our peak, if the business were to do as well as I would hope, we would never have more than 35 members on site at the same time. Now, all of those folks would not be driving themselves. We provide transportation for people as part of treatment, so they will likely be getting dropped off. We have an adolescent wings. The floor is already divided into two segments. There will be an adolescent side and an adult side, so we also provide adolescent care. they will all be being dropped off by someone. So maximum number of parking spots for membership, if there were 35 people on site at any one time, would probably be 20, and for staff, another 10.
Okay.
And not all members are there every day of the week. So we have the partial care program is Monday through Friday. Most folks come in at an IOP level of care, which is a 3-hour level of care, 5 days a week, then reducing to 3 days a week, then eventually reducing to just 1 day a week. So that's why the numbers they're not all ever there at the same time. We could have a full census of 90 people and never really have more than 35 people on site at the same time.
Sorry, could you just clarify again how many staff and members would be at peak?
At peak,
it was 20 staff and 35 members, like in the,
no,
in the
10,
letter?
10 staff and 35 members.
10 okay, because in the letter it indicated, I think, 20 staff and 35 members. But
maybe
okay,
we were being gratuitous. I don't know if we want to fall on the side of being more or less. I can't imagine 20 staff.
No, I just wanted to,
that would be a great ratio for my membership. But no,
and
10 would be a decent number.
And just to clarify, when is peak again? You said that was Monday, Tuesday, Thursday?
Monday, Tuesday, and Thursday are full partial care program till 3:30, but then again 5:30 to 8:30 at night. We do not offer evening programs on Wednesday or Friday night.
Wednesday or Friday, okay.
We will never offer evening program on Friday. If the program grew, we might do it on Wednesday. Never offer it on Friday. Nobody would come. We're not going to start with Saturday, but we may move to Saturday, which would be a 9 to 2 on Saturdays.
Chairman,
Yes.
would you be utilizing vans?
If I've already done a brief search of sober housing offered in Montclair. There are a couple of what are called sober houses in Montclair. If we were to use them, we would be transporting members from those houses to the facility in vans.
Okay. And
No, go ahead.
don't you have 2 parking spaces in the rear on the Glen Ridge Avenue side of the building there?
I was never told they would be mine.
I assisted in negotiating the lease, and
Oh, no.
we were granted no parking spaces.
Okay.
If you
No weekend services?
Saturday only. We don't offer them on Saturdays yet in Princeton, and we're open. This is our 4th year. So I only say that we may eventually, but we don't as of yet in Princeton.
Okay, thank you.
I just have a question or two about the concept here. People will come from sober houses to the facility and remain there for some period of time throughout the day? Is that how
If someone was coming from a sober house, they would likely be in our partial care program, so that would be 9 a.m. to 3:30, and then they would return back to their sober house where they would stay.
And what is the nature of what goes on in the facility that you...
Group therapy. Right now, our schedule in Princeton is group therapy for 3 hours in the morning for partial care, an hour for lunch, which we would be providing from local restaurants. So there'd be a lunch served to all our members from local restaurants, as well as a dinner for our evening program. So 3 hours of group in the morning, an hour of lunch, 3 hours of group in the afternoon, and then they would go home. They would be pulled out of those groups for psychiatric care, pulled out of those groups for individual care, pulled out of those groups for case management. The level of care that we provide is the level of care meant to reintroduce people back to their jobs and to their families. So there's a lot of case management that goes on as well as family therapy. So the 3-hour group is just the block of treatment provided to mental health and to folks with substance use disorder diagnosis, but they're not in the group for the full 3 hours. They're often pulled out for an hour for those individual services.
And you're not cooking?
No.
You're not doing it?
There is a full kitchen there already. Is there an oven? No oven. We don't cook. We cater in.
Thank you.
Okay. And you did mention that some of your members will be driving in. Have you taken any accommodations to facilitate that?
That will be transporting them?
Right, the members who are driving themselves.
Yes.
Have you made accommodations for their parking?
We spoke with the ownership or the management of the garage, and they would be willing to reserve, I think we said 10 spots for staff, so I would pay for those 10 spots for staff so that my staff can come into the garage at any time and have a spot. And then for membership, we could actually get a validating machine so that the members could park without being concerned for payment, come into the building, and once they're in for treatment, get their parking validated, and we would be paying for that as well.
And the garage you're referencing is the Midtown parking deck?
Yes.
I have nothing else.
Questions from the board?
Mr.
Chairman,
And I happen to know NK Design, it's NK Architects in Morristown. They designed the office building across from the hospital. So they're a large firm based in
The
Morristown.
MOB?
What?
The
Medical office
The
building?
medical office building?
Yeah.
That's what they do, yeah,
Yeah,
mostly
so they
healthcare.
specialize in medicals. It's NK and the A is Architects. So it's, so we know them, but that's.
Thank you.
Thank you.
They designed the building, the brand new one across
Yeah.
from the hospital in the redevelopment zone, right?
I spend time in that place.
Mr. Hernandez?
Yeah, thank you. Just a couple questions. Will the transport vehicle be stationed in one of those 10 spaces at the parking deck, or?
Likely, yes. If it's ours, yes.
Okay.
But sometimes if they're staying at one of those sober houses, those sober houses actually provide transportation themselves.
Okay.
So
But
you're
if they
pro-
don't, we would provide the transportation.
So if you're proposing to have your own van and you'll park it full-time in the deck, get like a 24-hour permit?
Probably. If we use a van, that would be the case, yes. Right now in Princeton, I don't know if dollars and cents make a difference too, but tens of thousands of dollars a month are spent on Uber.
On Uber?
On Uber.
We don't make decisions based on
I'm just wondering,
finances,
just how
just so you
serious,
know.
it's just a part of my commitment to
Right.
whatever we have to do to get them there, we'll do it.
Well, and we're asking these questions to understand.
How many spots I'm gonna do.
Yeah, how operationally, right? How is this going to work? Is it, you're gonna have a 15-passenger van that's gonna sit on Glen Ridge Avenue for a little while and wait while you unload, offload, or wait for people to come out of group? Like,
No,
those are why
everything would be
we're.
done in the garage. If it was my van, they would be brought into the garage and then walk from the garage.
Yeah, I think there'll be no unloading on Glen Ridge Avenue because the
Right.
bike lane is right in
Well,
front
and
of the
that's,
entrance.
that's why we ask a lot of these questions, right? Just how will this function, right? Whether, I mean, unfortunately, we can't consider cost here as a planning board. So however you do it. We just want to understand that operationally so we can either make a decision, does that make sense? Or do we need to have a condition on the application if we so approve it? Or, we think of something logistically, well, you can't park along Glen Ridge Ave because there's a bike lane, right? So part of it also is we give some advice if you're not familiar with the area.
Received.
Apropos of that, are most of the members coming from sober houses in
No.
and around Montclair?
No, 50% of the population will be mental health, at least. So only half the population will be there for substance use. There is no housing for mental health. It's actually a great deficiency in the state of New Jersey. It's hard to get them to open them up and to staff them. So only about 50% would be. At max right now in housing in Princeton, we might have 12 people in housing. So we are not a housing-dependent treatment facility, which is also very unique. Most facilities are, because that's the only way they can get them to come to treatment. In Princeton, we have 85% of our membership drive themselves.
But you wouldn't just have.
Or come via Uber. They're not captive in our sober housing.
Oh, I was just going to add, okay, so that's what I wanted to clarify. So it's not, people seeking substance abuse treatment wouldn't be all from sober houses. They could
Correct.
be living at home and coming.
100%. Most would be.
What would be the breakdown approximately of that population would be sober houses, people living in sober houses and people living on
So if we
on their
had
own?
20 people in our partial care substance use program at any one time, the program would be very strong. That's a lot of people in your partial care substance use. About half of them would be coming from sober housing.
Okay, so about 50-50, okay.
How many sober houses are there in Montclair?
First search I did was 2. One is an Oxford house and one is a privately owned. If I wasn't satisfied with those, I would pursue my own.
What, does that mean set up your own sober house?
Separate company, though. Has nothing to do with, it has to be owned by a completely separate company. It would have nothing to do with the living room at Montclair.
Okay.
You're not allowed to own sober houses and own a treatment facility in the state of New Jersey.
Are
Ms.
we,
Wallace.
is the previous use was an office?
It's actually a church.
Was this the Hillsong?
Yes.
So that's one of
Hillsong.
my other questions in my report was who are the other tenants in the building? Because I saw the sign for Hillsong Church. So they're no longer there?
They're still on the first floor, but looking to get out.
Okay.
We do have the list of all of the current occupants at the building
And this, and the.
and the square footage.
Okay.
So just to quickly go through that, there's Goji Superfoods on the first floor. They take approximately 1,100 square feet. There's Poe Ezra LLC doing business as Grafton's, also retail use on the first floor comprising 1,150 square feet.
Can you, that's
The legal name is Poe Ezra LLC, but they do business as Grafton's.
And you can forward that list to Ms. Talley?
Yeah,
so
if
that
you
she'll-
could send it, that'd
'cause
be
she's
great.
going to write that down, so.
Yep, I will forward this to you after the meeting.
And
Thank
to
you.
me.
And,
Thank
yes.
you.
So I guess my question is, are these uses that in the past got variances, or are these uses that predated parking requirements?
Well, if it's going from retail to retail, then it doesn't create a variance.
Okay.
What triggered this is going from
Medical.
going to medical office, regular office to medical office.
So the
which has
church
a-
was an office?
I don't
was
know-
considered office?
I don't know anything about the church
Okay.
use in this
Except,
building.
except Justin Bieber went there supposedly.
Well, I thought it
In
used,
town.
it used to be in the Wellmont Theater. I had no
That was a
idea.
different era of the Hillsong Church.
Okay.
I had no idea Hillsong was in this building
Got it.
until I saw the sign on the door, which is what prompted that question. How
Okay.
much, for instance, can you tell me what the square footage is that they have right now?
Right now, they have approximately 4,500 square feet.
And is that, well, you don't know, is that services or offices or?
It's a giant auditorium that they built on the first floor.
Really?
Yeah, that's where they would hold their services. It's beautiful.
I was not aware
So I
of
guess
that.
the second floor was probably the office, and that's where they did their admin from, and their
We
childcare.
used to
But-
do it in the Wellmont Theater.
Let's hope they
I
got
always
their
thought it was
approvals.
in the Wellmont Theater. I had
Sorry.
no idea they were
That
here.
may be where these questions are coming from, right? You know, going from A to B.
So just to clarify, it's
that right?
office to medical office, which triggers
Yes.
more parking than what was previous. Got it, thank you. And there was zero parking when it was office?
There's no parking.
Right,
yeah,
it's
so It's
an-
just that, it's
Got
just that our zoning ordinance, as it's written right now, when you increase the intensity of the use, it triggers a parking variance, which triggers an application to the board.
Got it, thanks.
Mr. Chairman?
Yes, I
Yes.
was going to say, did you get your questions answered, or do we
The one, yes.
jump all over it?
No problem. I do have one other question, though. Just looking at the architectural layout, it's just a little unclear. I see there's there seems to be a stairwell sort of fronting Bloomfield Avenue and another stairwell and elevator towards the rear of the property, or the building. Is your floor accessible from both frontages?
Yeah, in
Glen
fact,
Ridge
it's one of
and-
the reasons
and-
it was ideal. The entrance from Glen Ridge Avenue would be the adolescent entrance, because they're not allowed to mix with the adult population. So the adolescents would have their own entrance to the adolescent side, and the adults would come up through the Bloomfield Ave side.
Okay, so they have two exclusive entrances for the various programs. Okay.
If, I just heard there's a bike lane there, so if the Glenfield is the adolescent entrance, where would they be dropped off? Is that true? There's a bike lane on the Glenfield? Glen Ridge, sorry, Glen Ridge. So where would they, parents coming, dropping off an adolescent, where?
I'd have to look, we have actually signed the lease already. We've been looking at this space for 10 months, I think, and I was forced to sign the lease, otherwise I was going to lose it. On that street, there are, I believe, parking spaces no spaces at all on the opposite side of the bike lane?
No, it's not.
There are, right? There are some there, but further down the block, we can create, we would actually probably have a staff member out there to greet them. That's the way that we do it in Princeton.
There's
So-
not going to be any drop-off on the south side of the street.
But even if we went to the corner and where you make that first left, that street's often pretty open. That's where I've parked before.
Yeah, that would.
first left.
Forest
Is that
Street.
Forest Street?
Right, I'm just concerned parents rushing, dropping off kids, pull into the bike lane. So what type of assurance, I guess, could you try to give us that, with your staff, that wouldn't be happening?
I have a question. Why do you really need a drop-off? These are adolescents, right? I don't think that this is conducive for a drop-off area on Glen Ridge Avenue.
I was
think they'd have
assuming
to-
they weren't driving themselves.
Yeah, they could be, well, I think what you'd have to do is you'd have to park
Oh, I see.
And bring them in.
Yeah,
and
I-
bring them in.
Yeah, just, we're not proposing a drop-off
All right.
area. I believe what all
I'm
this.
mixing up my application.
Yeah, no,
Just trying to-
it's late. It's been a long night. So, but no, there would be no drop-off area.
Well, you did mention dropping off adolescents, so I think that triggered the question. So if adolescents are getting dropped off, then we do need to address it. So we do need to understand that.
Yeah, I mean, what we don't want is, say this gets approved and, you know, all of a sudden there is a lot of issues, or there are a lot of issues with people dropping off in the bike lane, it's causing conflicts, like, that's gonna be a problem, right? And so we're trying to head that off with these questions ahead of time, and if you're representing, hey, we're not doing drop-offs there, then, you know, if we look favorably upon this, we'll make that a condition of the application, so that if there is a complaint down the road, we pull up the approval and it says, well, they agreed that's not gonna happen, and so we would then fix it.
We've had the similar issue with another use in the downtown.
Correct.
Where a non-parking area has been used for drop-off, which is, we want to avoid that. So
Yeah.
in here, it seems to me, you can either park on the other side of the street, or you pull right into the parking lot.
Correct. And I
And you
assume,
can, it's big enough, you could either drop off there or pull in
Yes.
and park, and then it's very close.
As long as there was no concern, I was concerned that there was a concern about how many of those spaces I might be using, even if it was just for a moment to pull in and drop off. I was just trying to be conscious of that, but
Yeah.
that's not a problem.
Well, we'd
I
rather
can do
not,
that.
you not park in our
I don't want to block any
bike
traffic
lane.
either.
yeah, and that's the thing, is traffic, you know, whether it's pedestrian, bicycles, cars, you know, we have enough congestion in town overall, especially in that area, and so, you know, but we also recognize we want businesses there, and that's why it's the C1 Central Business District, trying to manage all these priorities.
So another point is that the mental health program starts at 10 a.m. So they're never getting dropped off at the same time. So the most people getting dropped off at like 9 o'clock might be 15 people, or driving in, not getting dropped off. And that's the traffic. It's 15 people at 9 o'clock, another 15 at 10 o'clock, and then that's it. They all leave, some of them at 2 if it's mental health, which is only a 3-hour-a-day program, and then some that are only there for 3 hours of SUD are leaving, and then others are leaving at 3:30, so it's staggered, it's very fluid, it's not a lot of people at the same time ever.
And then what about the evenings? I know that you're not doing Fridays and Wednesdays, but with the Walnut Theater being there, that Glen Ridge lot can get filled up. So how many people would be dropped off in the evening on Monday? What was it? Monday, Tuesday, Thursday? Is that
Monday,
what it was?
Tuesday, Thursday, the most people we've ever had in the building total on an evening is 20.
20 total, okay. And that, how many staff, how many members?
6 staff, 14 members.
Okay.
I just want to be very clear. There will not be any drop-off on Glen Ridge or on Bloomfield
Correct.
Avenue. Is that correct?
Correct.
And the applicant agrees to that. Next question. There are two options, option 1 and option 2 of these architectural plans. What is the difference, and which one is operative?
All right, so the only changes are on the adult side suite, which is the side on the bottom of the page.
On option 2.
And option 2, intake, office, storage. Option 2.
Yeah, we were still negotiating the lease when we had to put in the application, so we were still in the process of finalizing the architectural plans. So we'll be moving forward with option 2.
So option 2 will be the
Yes.
the final? Okay. Thank you.
Is there a staff change during the day?
Only that folks who stay until evening come in at Nikali. Yes.
I think we have to swear her.
We'll have to swear you in, but yes, absolutely. You can either use that microphone, you come up to the lectern, whatever's easiest. Mr. Neese to swear you in?
Can you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I did.
Would you please state your full name and business affiliation for the record?
Sure. Nick Haley Jones. I'm the Chief Operating Officer of the Living Room.
You may have to speak up just a little bit so
Sorry.
we can hear you.
Nick Haley Jones,
Thank
Chief
you.
Operating Officer. So it's a staggered schedule. It just depends. So certain people will be there from 9 to 9. Some will come in at like 11 staff members. Some work half shifts here and there. So it kind of just depends on people's availability at the moment and willingness to work. Some work 4 days a week, some 5, some part-time. So it just kind of varies. I do the scheduling, so.
Other questions from the board for this witness or the COO or COO? Yes.
I'm sorry, yeah, I'm just
Yeah.
mentally spongy from the last thing still.
With 3 hours straight up here?
So it is just one floor?
Correct.
Just one floor. And that one floor is the current tenant has been Hillsong?
In half of it.
In half of it. And it is recreational play and office. So it's a amalgam on that floor, is that correct?
That's what we were told, yes.
Okay, all right. And how long, is it vacant now?
Technically, yes. We signed the lease, so we're the leasehold
You're
tenant,
the
but
leasehold.
obviously we don't have our approval, so we're not occupying it yet.
Right. I'm just wondering, like, how, I'm not gonna hold you to anything, just like, how intensively, in your understanding, has it been used recently?
I can answer that. Hillsong uses it for their Sunday services. I believe they have 2 services. And when I was talking to the pastor, he said it's about a couple hundred people per service.
Okay.
And the upstairs, which is what the second floor, which is what we're going to occupy, it was mainly for their children program, of which they would have like 30 to 60 kids up there.
When they were having services
When they were having
downstairs?
services, yeah, but Sunday only. Occasionally, they had like a event here or there on a random night, but pretty much only Sundays.
And then, to the best of your knowledge, they are retaining that nicely fit out space on the first floor?
Yes, for now.
For now.
But I believe they are trying to find an alternate spot. The spot you were mentioning before, they had that prior to COVID. They said COVID, their numbers dropped, so then they had moved.
Right. So what I mean is, where I'm kind of going with this is that, like, so they are going to still be doing services, but they won't have an on-site place for the kids of the parishioners.
They have a pretty large downstairs, so
Oh,
I don't think they have a plan for it. I think it was just more out of a little bit of convenience, but I'm not positive on their exact plans for it.
Okay, I got it. Engineer Hernandez, in our discussions that we've had at the township level about pickup and drop-off, have you been in those? Some of those, not really.
Not so much, it's more of a complete streets director
Yeah.
issue. I know he's been, Jacob Neiman, our director, has been.
No, just because
tackling that issue.
there has been movement on creating more space mid-block on some of these blocks to do pick-up and drop-off spots. I find it a little complicated to understand exactly what's being done also, but I would imagine that would be taking place possibly on this block as well. So the idea that people are not going to drop anybody off, that's, something's always going to happen, so just again, to get it on the record, you were saying that all drop-offs would be done at the garage?
Needed, absolutely.
If needed.
I mean, currently just as an ad hoc, most of the parents will walk their kids from our parking lot. So it's usually not really a drop-off situation. They like to see them.
What are the age of the children that are?
12 to 18, 12 to 17.
Okay.
Yeah.
You said most, how many would you estimate, like at the Princeton site, for example, are dropped off?
So I'm just doing quick math of our individuals that we have right now. Most of them, I would probably say 75%. And we have,
Are walked in?
yeah.
So about 25% are dropped off?
Well, so there's a few who drive, because they're 16,
Oh, sure.
17. So there's
Yeah.
a few who drive. That's what I
Okay.
was thinking of. But by and large, like, parents sometimes arrive early, then they know, like, when program ends, you kind of walk them out. or they're utilizing rideshare Uber programs too, because we have like Uber Health, it's safer for kids. But I think similarly, we just would have to designate the spot. We're the ones who call the Ubers, so we would just have to make sure we have the right spots. If we just don't put an address that isn't able to be dropped off at, I think it's pretty.
And if I can ask, the Princeton living room is in a similar type of building that's in a, it's not in a strip mall location. Can you describe what the Princeton building looks like?
Yeah, it's an office-style building, so does have some parking spaces right now, has like a parking lot on either side of the building. It's off a major road, 206, but it's mainly office buildings at the moment.
But does it have, would you say, surface parking lot that would absorb your capacity?
Yeah.
Okay, so that's different.
Chairman?
Yes.
Just a couple questions just related to earlier in your testimony. You indicated that lunch would be provided through a catered surface, although I think you said there is a kitchen, a full kitchen provided within the...
No, well, kitchen's primarily for
space.
coffee and refrigeration of snacks and stuff. We have a lot of snacks laid out all the time. All meals are catered in from local restaurants.
Okay. So can you just, is that something where one of your staff members would go pick up and bring in and disperse? Okay. Can you just walk through a little bit then, how will the trash be handled that's generated for the daily lunches? Looking through I think you said option 2, right, would be the prevailing layout. I don't see like a dedicated trash room. I see a storage room towards the Glenridge Avenue side. I'm not sure if that's where trash will be stored.
In Princeton, where our census has reached as high as 90, we have 2 traditional kitchen-sized garbage cans on both the adolescent and adult side. They're emptied and taken to the dumpster every hour.
Okay.
So we don't keep any trash on site for any length of time.
Well, is there a dumpster for this building?
I don't know.
I don't know how this, I don't know the trash management plan for this building.
We would, if
kinda what I'm getting
if
at.
necessary, we would modify it, if not with a dumpster, with just more frequent pickup of whatever cartons are capable of being stored there.
Okay. So you'd be hiring private hauling for trash
Absolutely.
pickup? Okay.
So I'm a little confused. The building itself has other tenants. You will be part of those tenants using the building's master trash plan, or are you arranging your own trash pickup with a private carter?
We would arrange our own private.
You will do that?
Yes.
But you have to figure, where would you be, then you need to know where the dumpster's located.
Right.
Yeah, actually, I don't know. Nicola, did you notice?
I don't, I'm sorry.
No,
Yeah.
I didn't notice.
Because I know it's an issue regarding just trash and it's
You
particularly
can't just
food.
put it out on the street. Yeah.
Right.
Yeah.
And you can't put it in our trash bins. You have to have,
I think it's something that you need to think
Perhaps-
about a little bit more.
Well, the building had a bakery in the basement at one point. That was what the basement was originally. It's been
So they
vacant
must-
for a
there
couple
mu-
of years.
my suggestion is if the board approves this, one of the, maybe a condition could be a trash management plan be submitted.
Yeah, I think it, again, you've heard this theme a little bit here in our discussions, like, we want to make sure it works. Right?
Absolutely.
Whatever you're proposing works.
Absolutely.
And doesn't cause other issues for other folks in the township. So that's why we're asking that, whether it's private or you're part of the building's overall trash management system, I don't think it matters to us necessarily. We just want to understand that you have a plan for it, right? And that you've got space within your tenant space to hold your trash and you have a place to put it overall. That's where these questions come from.
No issue making that a condition of approval if this were to be approved.
Okay. Other questions from the board?
Does the Princeton location or the model have any notable security protocols or anything like this?
Doors are always locked, keypad entrance, cameras inside and outside.
And there's a member of the staff is like sort of, there's a security.
There are two staff members. One, it's called the green room, the first room you walk into. It's normally a waiting room. There's an attendant in the green room at all times that does all camera identified entrance.
And your Princeton location's been in existence for 4 years, you said?
We're going into our 4th year, I think.
Okay.
Do you anticipate security similar to that here?
100%, if not more. And when I say more, it's just because it's more urban. Like, we don't have a problem with staff members being paid to greet our members at the door. Like, waiting outside to greet them. Waiting outside to meet them where we decide they're going to be taken into the garage or whatever. We'll hire people to do that. This is not, it's concierge treatment. It's much higher level, so we don't let people wander around or walk around or do anything. You know, it's all handled. Their coats are taken from them and hung up for them when they come in cold weather. Like, it's a very different model. So there's no issue. Whatever needs to happen, I'll make happen. And I don't cause problems for people. It's just not who I am. So if there's a problem, I take it very personally, and I find a solution for it.
We appreciate that. We just want to make
But
sure it happens in practice,
sincere.
right?
Just look up my history. It's just how I operate as a businessman. I can't do it any other way.
And
As a sober man, I can't do it any other way, to be honest with you.
And you said earlier that, the adolescents will be coming in from Glenridge Avenue, and your other clients will be coming in from Bloomfield
Yes.
Avenue. So you'll have people waiting at the door at Bloomfield Avenue?
Not for the adults.
Not for the, I'm just trying to understand.
Yep, just for the adolescents.
Now, if the adults are driving there, they park in the parking deck,
Yep.
they have to walk, they're not going to walk to the Glenridge Avenue entrance,
No.
they have to walk up the little alleyway and then along Bloomfield.
Depending on which way you walk out of the garage, because if you walk out the entrance off of Glenridge, you can just walk up Glenridge and around the corner to Bloomfield. They have other ways you
Yeah.
can go up that alleyway, which I
Yeah.
figured out too.
It's not that far, it's just a little bit farther,
Mhm.
okay.
The floor itself is fully integrated. There's no, the adolescents can go to the adult side, or, so there's no
Completely blocked off.
communication.
Windows even need to be tinted so there's no visual.
Is
Okay.
that the red lines on your map, your plan? Oh, that's the original space?
Yeah, so the adolescent side is the entire space above what is labeled as the waiting area.
Okay. All right.
So they're the Bloomfield facing side, Bloomfield Ave facing side.
So then what are those red lines?
I'll have to ask my architect.
I think those are separation of spaces. like,
The original.
There's a dedicated office
Oh.
space use,
Uh-huh.
and then I think it's IOP 1 and IOP 2, which I assume is the adolescent and adult programming spaces. Is that?
Yes.
That's my interpretation.
Intensive outpatient is the generic label of the level of treatment we provide.
Right.
Intensive outpatient.
Is this a voluntary program?
Entirely.
Other questions from the board of either of these witnesses? Questions from the public of these two witnesses, which I have to ask. I don't see anybody in the audience, but I have to ask. I see none. So if you have another witness.
Before you move on, I just have another question about your operation. It seems to me that if you're able to get people from the sober houses to come to your facility, how do you get the referrals for the adolescents and the other adults who don't come from sober houses? Where does that come from?
The primary vehicle that we currently use is word of mouth and branding, but until that happens here in Montclair, it's pay-per-click digital advertising.
I'm not familiar with that. What does that mean?
It means a tremendous amount of money being spent to make sure that when
Media
people
spend.
search, I need treatment, my facility comes up first. That's the primary vehicle, and it's a very competitive market in New Jersey, so it's...
Google, social,
Yeah.
prospecting.
And do you have, maybe this is not my business or the board's business, but what would the cost to a member be to be part of your facility?
Depends on what their deductible is and their co-insurance, but it would be covered by insurance. It's just an insurance policy that has out-of-network benefits.
And so you would just accept insurance? You don't accept anything above the insurance payment?
We don't ask for anything. We don't balance bill, so we don't bill what insurance doesn't pay from our daily rate. We don't do that. We don't have to do that by law. What we do have to do by law is make sure they pay their deductible and any of their co-insurance until their max out-of-pocket is met, which we do. So for some people, that might be $5,000 for 3 months of treatment. For some people, it might be 15. And we also, because of the level of care we provide, eventually do draw quite a few cash pay clients. We usually have 1 or 2 at least in our membership at all times, people who are choosing to come and pay cash.
Thanks.
Do you have other witnesses?
I do, if you will hear him. Justin Taylor from Dynamic Engineering.
Sounds good. You can stay. I'll stand up here.
You've done this before, I can
Once or
say.
twice.
Yeah. So, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Would you please state your full name and business affiliation for the record?
Yes, it's Justin Taylor. Business address is 1904 Main Street, Lake Como, New Jersey. By way of background, I hold a bachelor's in engineering from the University of Delaware. I'm a licensed engineer in the state of New Jersey, as well as Pennsylvania, Delaware, and Texas. I'm also a certified professional traffic operations engineer by the Institute of Transportation Engineers. I'm practicing traffic engineering for, almost 25 years now, and I've testified at hundreds of boards throughout the state of New Jersey, including this board, but it's probably been almost 10 years, I think.
Yeah, okay, but is your license current?
My license is current and in good standing.
Do we accept him as an expert?
Yes. So, for the sake of time, I can be brief. The reason I'm involved in this project and the reason that we're here before you as opposed to just a tenant change is the fact that this medical office use generates a greater parking demand than what the existing uses are. The square footage that we're talking about is about 6,700 square feet for the total floor space. It's currently allocated, at least per the board's review, of about 3,700 towards child play area and about 3,000 towards professional office. When you apply your ordinance's rates of 1 per 200, 1 per 250, it generates a parking demand by ordinance for the existing space of 31 spaces. We're coming in, making it all medical office, which is 1 per 150. That translates into a parking demand of 45 parking spaces. So we're talking about a deficit or a change in demand of about 14 spaces, hence the variance, and hence we're before the board. So when we look at parking variances, we look at a couple different avenues. Sometimes we go to ITE, right, when we're not 100% sure what the demand is going to be. The Institute of Transportation Engineers would say that this type of use, if you were looking at square footage, of 18 parking spaces, demand maximum. If you look at the number of employees, it would say 26. Both are below what is actually per ordinance the existing use. So I think there's an ability there to say that the demand that we would be generating, even though your ordinance says a little higher, is below that. But you've actually heard testimony tonight of exactly how this is going to operate, right? Doctor is proposing to get 10 spaces for employees in the Midtown deck, right? That comes out of that 75 that are allocated to the local businesses. So that's not in the general populace. Those spaces will be allocated as part of that. Then you hear that he's going to have a lot of drop-offs. You're going to have people that drive themselves. But what we needed to look at, say there were 45 people. Is there sufficient parking within that in that garage to accommodate that demand? Whether it's 14 we're talking about, whether it's 45 total per ordinance. So we went out and looked during their busiest times. Monday, Wednesday, Friday mornings is when they have their maximum number of employees and staff. What was quoted was 20 and 35. And what we found is in that lot, there are a minimum of 125 spaces available, right? So that can easily accommodate what we're talking about here, even if everybody drove, every single employee drove, every single person came together in a car. So to really sum it up, I think that the board can feel comfortable granting the variance that we're asking for from this parking generation based on both the ITE numbers that we would project for this site, but more appropriately,
what's available in the deck and what the operations of the current tenant would be.
What were the dates that you?
We were out there on June
So-
1st.
Yep.
And that's it. Honestly, we didn't have much time, given the report that we got and the 10-day rule that the MLUL requires. So we sat with the applicant, came up with what their busiest time would be, and then went out and collected the data during that time.
What's the, maybe you don't know, what's the status of an agreement with the parking authority for the use of that deck?
Ready to pull the trigger.
Well, what does that mean?
Just with the microphone, if you wouldn't mind.
Nikayla, you spoke to them last?
So I called or talked to Francis over at it's Midtown Parking Deck by Reimagine Parking, and he just said the process is we can get a validator, a machine, or stickers for it, and that's all we had to do to get set up in terms of being able to work with them, and that was kind of the extent of it. So I think.
But they've committed to your request for the 10 spaces?
Yeah. So when we talked to them, we said that we need 10 spaces for staff. They said that's fine. And then the rest were people coming in and out in terms of validation.
Are those daily permits? Is that what are they selling? Because I thought it was all metered in there. Do they sell permits?
There's permits.
They sell permits.
And there are 75 spaces allocated in that deck to local business for employees for exactly this use that we're looking to do.
Yeah, there are permits. On
No,
the
so
upper
it's
floors.
permit.
They pay for them, obviously, but
Right.
they're allocated towards that for this exact reason, knowing
Got it.
that this block has, most of the buildings have no parking to themselves.
And there are 10 available, 10 spaces of those 75, did you say?
That's my understanding, yes.
Do you know how many are available in total of that 75?
I do not know.
And they're not assigned, right? You just park wherever you.
For the employees, it's a separate cordoned off area. For the clients that would be coming, or the parental drop-off, then they're going to walk them in, it's all open after that. So they would go, they would park, they'd walk their children in, or they would come for their treatment. They would then take the validated sticker, and out they go.
But those would be in the metered parking
Those are the metered
spaces.
parking spaces.
Yeah,
That's
so
correct.
I would guess they probably push them way up to, like, if you're there for the day, you can
You
grab
mean-
them way up top, right, to get out of the way of the retail
Oh, yeah,
for
I mean, if
employees.
there's a patient or a customer who's
Well,
parking himself.
yeah, I mean, if you get a permit, if employees park for the day, they probably would push them up in the garage.
They're up at the
usually.
top,
So they're
yes.
not occupying the handier spaces down below.
Yeah.
Okay.
That's correct. I mean, I'm not 100% of their operation,
Yeah.
but that's
Well, that
usually
makes
the way you
sense,
do it.
yeah.
Yep.
So is it, for the employees, do you know whether or not you're just going to have permits, or will you have a written agreement with the parking authority concerning those 10 spots?
I have to go back into our email. I just remember him saying 10 spots was not, he could go up to 10, and that wasn't, wouldn't be pressing for them. I don't know if we'll have to do a written agreement from that. He said the next step would be to go through the Montclair Parking Authority in terms of getting the validation stickers and all of that, so I'm not positive offhand.
I'm sorry, he said up to 10 spaces, or there could be more?
He said for us, he could do 10 spaces for staff.
He could do 10, okay, but there was no conversation about potentially doing additional spaces beyond that?
No, to be honest, this was like an initial conversation that we had in March
Okay.
when we were first talking through it, and then since then, I actually just moved up the street, so I've been walking back and forth, so I haven't actually gone to the parking lot myself a lot, so we haven't done much more than
Can you say that again, please?
When did this garage open? Anyone know?
About 2022?
Okay, so
It
it's
was
been
very-
open for a while. So people, if businesses wanted to buy out all the employee parking, it's been open for 3 years.
Yeah.
Is that what I'm hearing? Okay.
It's not too utilized if you ever wander around. Pretty.
Yeah. Again, it is though on concert nights in the
Yeah,
Wellmont.
that's about the
Yeah.
only time.
Yeah, yeah.
Never fully, Janice,
No,
could you-
I've been blocked out of it before.
Out of the
Yeah.
Motown deck?
Mhm.
Ooh, I never have.
Yeah.
Can you refresh our memory? The 1 Seymour Street
Yeah.
resolution had them mandated to do validation for that medical
For their
use?
medical office use? I don't know that level of detail. All I remember is when that was approved, we knew that they were required to have office. It required in the redevelopment plan. They designed the parking deck to address the office parking, we never got down to this level of detail when we approved that parking deck. And
I
that
don't
use.
remember it as part of the.
Yeah, it was
resolution.
integrated into the overall parking allocation for that deck.
Interesting thing, which I go to that medical facility too often, I would admit, and you are definitely just always validating. Like there is, when you walk in the door and everybody just hits it, so,
Yeah.
and they're paying a lot, and it smooths it out so that they're not blocking out the machines in the place. So it seems to me that the one big question that I have is still the drop-off, and the drop-off at the garage. And I do not see, maybe people have looked at it more closely, but it's a little bit of a weird spot of how you get into the garage on the west side of it. And so where exactly people would be dropping off if there are people being let out of cars there, it's not totally idiot-proof. Like,
It isn't, but
yeah.
It isn't, but, again, I'll put a staff member out there to make sure that it doesn't happen where it's not supposed to happen at all, and any times people would be dropping off. I don't know what's behind the building. Someone suggested there were a couple of spots. I know there's room back there. There could be room back there before you block the entrance to the garage in any way for that to happen, or we find a way for it to happen in the garage.
Perhaps we include a requirement that he work with the Complete Streets Director to identify an appropriate drop-off location on Glenridge Avenue to serve this use. And there's other businesses that could
Okay.
use a drop-off location as well. And when I say drop-off, I mean short-term parking, not like childcare drop-off, but a short-term parking spot. It might be on the other side of the street, but that's something that the Complete Streets Director can work on, because it would be a council decision.
The other thing just to note is that these are members who are returning usually day after day, so this isn't like random people coming in and out. So it would be a learning curve the first day, but then not after that. And so if we, get our speech down of where people need to go, it really shouldn't be a consistent problem with people. Just
Give people a map, show them like, here's where you can actually drop off, here's where you definitely cannot drop off.
Yeah.
Like, those types of things would be helpful.
That's
and-
my
and-
that's my thought. We kind of like to do processes and protocols, but we're seeing the same people each and every day for months at a time. So I don't anticipate it being like a consistent, oh my goodness, all the time, like 15 people not knowing where to go and all that stuff.
So when you work with the Complete Streets Director, make sure you be prepared for places for bicycle parking.
Sure.
To follow up on that, how long do your patients work with you?
Yeah, usually anywhere from 3 to 6 months,
Okay.
average.
Other questions from the board? Any questions from the public for this witness about his testimony this evening?
Thank you.
I see no one.
I have no further witnesses.
Okay. Any member of the public wish to make a comment on this application? I see no one.
They're all jumping up out of their seats for
You know,
that.
we've got to ask the question. Someone might come running in from outside and say, I would like to say something. Do you have any last words for us?
Just, it's very late, so I will not bore you with a elaborate closing, but just based on the testimony presented this evening, I do believe this board can grant the variance with the conditions that we discussed this evening.
Would you consider, what was the increase in the parking demand? It was 14 spots?
That's correct.
I would almost feel a little more comfortable if you covered that deficiency. Would there be a chance for the lot to give you an extra 4 spots, go from 10 to 14? Is that a possibility?
Certainly ask.
All right.
Certainly happy to ask. I'd be reluctant to commit to
I
that.
understand that, yeah. I don't know, does anybody else have a thought about that?
Well, that's for employee parking. Do you need 14?
Well, it says up to
Spots.
20, in here, in the letter, it says it could be 20 employees, right?
And is
So-
everyone driving?
I'm not, but
Oh,
no.
all right, so then we're down one.
Yeah. Oh, we'll see, because public transportation is obviously obviously is good around here. And honestly, I counted the other day, there's nowhere near 20 staff members at any one time. It's closer to like 10, 12.
Yeah, I would
But you
just be
also-
concerned requiring them to
But they also talked
take out
about-
more parking than and just have spaces not being
That's fair,
utilized.
but do you have greeters at the Princeton location to show people where to park and to show them the wayfinding to the entrances?
No, like not that specific thing in terms of, because it's just not that hard to find.
Right.
But yes, we do have people who are staffed at the front desk the entire
Your
time.
point's well taken about other businesses that might need those spots, but I mean, to your earlier point, they've had 3 years to request them.
And I guess I feel like this is, as opposed to me going to my doctor's once every year. I mean, this, as I said, it's day after day after day. It's repeat customers for, sounds like about 3 months. So it's not like people are going to constantly be making, oops, oh, I didn't know I could do that. And so, I guess, right, a condition would be really enforcing that no drop-off in the bike lane. I don't know, it was sort of unclear what's on the Bloomfield Avenue side. I assume it's just parking spots, so.
Parking spots, yeah.
No double parking to drop off. But I guess that makes me less worried, given that it's a consistent population coming again and again. And even if it's parents bringing kids, it's again the same, presumably the same parents bringing the kids.
Yeah, fair point.
I guess this is sort of the opposite of the Ascend facility, that was.
And I also think, I mean, at the times that we're talking outside of a Wellmont event, I think there usually is plenty of parking in the Midtown deck.
That's fair, and the earlier parking they would get there before the rush for the concert.
Correct.
Right.
And that's something they would have to manage, right? If people are coming on a concert night, they've obviously published those schedules well ahead of time. You'd have to manage something like that and just try to figure it out without clogging things up more. But on a Wellmont night, it's busy around town.
Yeah.
So I would.
You'd be more comfortable with the 10?
I'm fine with the 10.
Okay.
I think there's enough parking in that deck, and especially if people are coming day after day, for months on end, they're going to get to know the deck and the ins and outs and be very comfortable going in and out of that deck. That I don't think we need to tie them into 4 more spots at the employee
To meet the
level. I think there's going to be
deficiency, okay.
plenty of open spots. And I mean, the report, the parking report, even though it's only for 4 hours on one day, I mean, it does show availability that's consistent with my own experience in the Midtown deck. Even on weekends, I find the Midtown deck has availability, whereas the Crescent deck, I showed up the other day and there were 0 spots available.
Another thing I'm thinking just different than the typical medical office is the people are there for 6-7 hours at a time, as opposed to you got in and out and in and out and in and out. It's sort of an in, you stay, you leave. So it's not even that much. They find their spot, and I guess you can't do meter because you'll be feeding your meters all day. So, they're just going to be in their garage parking.
Yeah, I think it's got to be in the deck. The meters, won't work, even though there are meters available, but I just don't see it's practical. And I think especially given, I think the township is talking about shifting some of the meters, timing and things like that, and cost and stuff like that, so to encourage more turnover.
Turnover, yeah.
So I think it's
Yeah.
going to get harder and harder to park at meters, at least for long-term uses. The short-term that we're trying to encourage, I think as a township, it'll make more sense. Other thoughts, questions, Counselor?
I'm just thinking back to the recent application from 56 Park, which was a similar thing, and I don't know where we landed on the number, and I know that we're not precedent-based, but it was far below the 6.6 per 1,000, right? It's the same use, correct? It's medical office.
It's medical
Right, I
office. at
assume
that
we're
place.
talking about, Mr. Taylor, right? The ITEs, 6 point.
2.63.
But we'll get you on the microphone here, because I think you probably know exactly what the counselor is speaking about, and maybe you can talk about how this compares to that. This application compares to
Yep.
the ITE for that.
So the ITE numbers, per 1,000 square feet is 2.63 spaces per 1,000. right? Or 1.28 per employee.
Right.
When we apply that to this, we come up with a demand of 18 spaces per per the square foot calculation, or 26 per employee.
1.28, like more cars per employee? What do you say, 1.28 per employee?
Correct. So what that does is incorporate both the demand generated by the clients and the employees. So when we see in a typical medical use, your employees drive and then you have patients that are clients that show up. So ITE demand for the medical office is 1.28 per employee, if you were to look at the employee basis. If you would just translate it into square footage, right, the 6,700 square feet, the rate is 2.63 spaces per 1,000 square feet.
For employees and patients?
For employees and patients, that's correct. Yeah, when we collect that data, we know what the box is. I don't know who's in or out, or we get the number of employees when we count it, type of thing.
Are you capped, you're a state-regulated business?
Yes.
And so is there a max number of patients you can have in your facility at one time?
There is, but the regulations just changed. It used to be based on a licensed clinician to member ratio, but that's been done away with. So there's a lot of stuff that's being thrown up in the air right now. So right now that would be largely just based on square footage and probably fire code.
Okay.
But again, we're not about big.
No, I know.
Yeah,
I'm just...
but we could be, yes. I imagine, I just don't know what that number is.
Okay.
Well, so the use of ride-sharing services, which is great, fine. You would expect that that would be also very high here, as in Princeton, correct? It would be very high. It would be high.
Yes.
I'm not trying to trap you.
Yes.
I'm just,
Yes.
No, I'm just waiting for her to
Yeah.
answer.
So I think that these are wonderful minutes, by the way, from that meeting, which mentions that the IT's recommendation dropped from 3.5 20 years ago down, in part because of the rise in ride-sharing options. So people are not driving and parking, they're coming and getting out of a car, which means that logically, your parking needs are lower than what they might have been before, or, are manageable. But it also does mean that the drop-off thing gets, because you can't say people are arriving in a ride share, and then also people are coming over and over and they know what to do, because the ride shares don't necessarily know what to do.
But we can choose the address for drop-off on the rideshare app.
On the rideshare app. But if
So we
it's
can
if it's
direct it to a
tricky,
place.
But if it's like inside that garage,
There is the short-term parking area of that garage on the east end, which might be more conducive to.
Oh,
so you're not
that's
going-
right.
So you're not going through the gates. It's like
Right.
15-minute
Yeah.
parking. And to me, that allows an ability for the vehicle to pull in, somebody to unload, and then they're just walking a little bit further up Glenridge.
By the bike store entrance, I forgot about that, because I don't normally use that entrance. I go through
Yeah.
the gated entrance, but there's a few spots there, right, that are short-term?
Yes, correct.
there you
At the
go.
east end of the garage, as you come up to the stop sign, there's an entrance there that has a
Yeah.
sign for the bikes, which is also short-term parking.
right, it had to be because of the access to the back of the building there, the
Correct.
bikery in there.
Right, so-
But if you drive into it, to get out of it is somewhat, you have to actually go, you would generally exit going west and then making
Yes.
a U-turn.
Yes.
It's not uncomplicated. It's not great.
And also, this business is on 4 bus routes, right in front of your
Yes,
building.
yeah.
There are, absolutely.
Yeah.
Now, the availability of mass transit to this location
Yeah.
is great.
Any other questions from the board? No? Thoughts on next steps from anyone?
just to, the condition is to try to work to find the drop-off location, if not in this garage, which I can't really picture, and then, just making sure enforcement of the no drop-off in the bike lane.
And garage plan, garbage plan.
Yeah,
And the garbage bin.
Yeah,
Okay.
so no drop-off on Bloomfield Avenue
Right.
unless it's a designated short-term parking spot, no drop-off on, like,
Well, if
say
it was an
Glen Ridge.
available parking spot, a car
If
could-
it's available parking
Parking spot,
spot.
a car could
I was
pull in
thinking
and drop
Bloomfield
off.
Ave, and I said Glen Ridge Ave, and
Right. Glen Ridge, no drop-off ever.
unless maybe across the street.
Across the
you know,
street, if
just
there's
not in the
available
bike
spot.
lane, Right,
Right,
no
yes.
drop-off in the bike lane. You'll work with our Complete Streets Director to identify a suitable location in that area. Could be in the garage, could be in the short-term area. That tends to fill up from my observations. So we'll have to work with that.
And the 10 employee spots as well, right? We'll
The
make
10
sure
employee
there's
spots.
some parking.
You'll provide us some evidence that you've purchased those, whether it's an agreement or, of course, invoice, whatever makes sense.
Also, there's no cooking. All meals will be catered, no cooking on site. We discussed trash management plan. Work with Complete Streets Director. That's all I got.
So I think I heard a motion to approve from Mr. Campbell. Is there a second? Subject, subject to the conditions we just enumerated, plus our standard conditions, which are typical. Is there a second?
Second.
Ms. Wallace?
All in favor?
Aye.
Aye.
Opposed? Abstentions?
I'll say Mr. Eadwali abstains.
Well, thank you so much. It was a really late night, and I really appreciate you guys staying out late.
Thanks for
And
sticking around
And
as well.
I appreciate you not making anything an issue about what I do, which is help people who are struggling with addiction. That means the world to me, so thank you very much. Thank you.
People need that service, so thank you for bringing it here.
Much success.
Thank you.
Safe travels
Okay.
home for that next hour or so, I guess, huh?
All right,
I have to drive back to Doylestown.
do we have any committee reports? I hope not.
No, I'm still trying to schedule that meeting with the master plan committee tomorrow.
Wednesday.
It's Wednesday, yes.
7 p.m.
And with you and Mike, are you going to be, you're available, right?
What dates, times we're talking about again? Sorry.
Wednesday, I think at 6 o'clock or 7? 7, okay. So it's going to be a Zoom meeting.
Wednesday at 7. Let me just, let me connect through the offline tomorrow. I'll see.
Okay,
I might have a
all right.
conflict.
I was going to vote yes.
Yeah.
Yeah, I'm just trying,
I was a yes.
I always
You
find it better
abstained.
This is one
to
of
talk.
those.
You abstain.
Because there's
Yeah, this is
some,
one of
I think some subject matter that we need to actually discuss, that came from council. Yeah. I don't think it'll be longer than that. I'd like to keep it in, these discussions in smaller content so that, it's not a huge time commitment.
Okay.
Okay?
And what about that? I think we should really follow up with your idea of the
I was
ad
just gonna
hoc
say that.
committee.
I was just gonna say that.
I'm willing to do my time,
That's great.
about looking at the zoning maps and just
Well, we have
making
a
sure.
zoning, we have
I
a
was-
zoning
yeah.
subcommittee.
Oh, you do already?
That's what I was going to say.
Yeah.
We do have a zoning
So now that-
subcommittee.
Takes up a lot of space.
Yeah,
That's where I would suggest we start.
That's a
And
good
I
idea.
have
Who else
been-
is on the zoning subcommittee? Do you have that
Um,
available?
Oh, wait a minute. Zoning subcommittee.
That's fine, but I think we should take some
It's
leadership
Carol,
and get the process started.
Eric, and Tony.
Oh, good, Tony's on that too. Okay, good. The zoning subcommittee, we were discussing following up on the maps and
I've
taking a look.
I've dusted off the zoning changes from 2018. Remember, I think, were you on the zoning subcommittee in 2018 when we
Yeah.
did those tables?
I think Tony's always been
Which I
on-
thought was
yeah,
great.
on it.
What is it?
A table format for permitted uses. I would love to move ahead with that again, because we did it in 2018. The council at that point did not want to adopt it, but it would make things absolutely clear what's permitted in the different zones and
Yeah,
how
and
they
we
compare.
meet jointly with the zoning board, right? Because Bill Harrison would join us occasionally, right?
Oh, I still think we should have Bill Harrison on this committee, because if we don't,
Oh, he's no longer on the zoning board, though.
I know.
Correct.
But we can have
Oh,
a
but you still
council
have-
member
you
on
still
the
have him,
committee.
okay.
Well, I mean,
Because-
he's a counselor now.
Oh, yeah, right.
And that way, it's better to get his comments in earlier rather than later.
Okay. That's
So,
good.
And then after we report here, we can discuss the communications committee pushing out the findings and
Yeah.
letting them, the
That's, I
the
think
public,
that's wonderful.
public know, yeah.
Okay.
And maybe the next steps with the council as well, what, if we have recommendations, we can
I mean,
discuss
honestly,
that.
these changes were from the 2016 Master Plan Re-Examination Report, and our master plan is just,
Yeah.
it takes a long time to get them approved.
Yeah.
As you can imagine,
Mhm.
when you try and get councils to adopt ordinances, so,
But
yeah.
pro-
Sometimes we'll just pass it without.
And we may want to get, and per the public's comments tonight, we'll probably want some comments from them on whatever the findings are.
Yeah,
from the committee.
absolutely.
So,
I think
Okay.
everybody loves the idea of having the people seem to like the idea of having the option of the bumper property, the last property in a commercial zone, to be, not have to have commercial use in the ground floor. Like that's one.
I actually think we might need to rethink our requirement to have commercial uses on the ground floor. I
For
think
NC.
maybe we should, with what's going on in the retail, maybe we should be a little bit more flexible. So these are the kinds of things that I think we really need to talk about. All right?
sounds
I
good.
actually have a question. I wasn't here for the meeting, Chuck was here, but I think it was you, Counselor, who suggested that there be a voting block at the end of the resolutions, both for the vote and for the memorialization. And I wasn't clear on whether or not you wanted that on each and every resolution or otherwise.
I would like it. I mean, it's what you see on an ordinance, and so, and then you don't have to write it out. You can just, leave it there. So you should be indicating, what actually happened, a record of what happened on the vote, and
Kind of like what the council does.
yeah, just a council voting block, and then, then we did clear up that apparently long-running, whatever misunderstanding that people who vote against something should not be voting for the memorialization of it. They should be abstaining. So.
So then I'll just put it on all
Yeah,
of the
it's
resolutions
easy. I
from
mean,
here
yeah.
on out.
If you could get, you'd probably get the clerk to send you a similar.
It's already created, I have already created.
Yeah,
I
in
think it's
Word,
Actually,
so
on
it
one of the
all looks-
resolutions.
I think I
I've
saw it
already
on
done.
one of
Yeah, I did see it, yeah, great.
Wait, what was that? If you didn't vote for the thing that passed, you don't vote on the resolution?
You're not supposed to vote for the resolution, you're supposed to abstain.
Oh, okay.
Correct.
Bills.
Is there a motion to pay the bills?
Well, I saw one bill from the engineering firm and not the attorney, so I think this is an easy motion to approve.
Second.
All in favor?
Aye.
Okay.
I'd move adjournment.
Second.
Bills in too late.
All those in favor?
Aye.
Aye.
My
Opposed,
assistant was
abstentions.
out.
Have a good night, everyone.
Good night.